May I please allow? Let the matter be come for listing on Wednesday. I have filed it on 24 by motion.
Okay. New matter.
New matter.
We took out the policy regarding item number 22. It's joint tribunal. Could it be just after the puja, Kali Puja, after the one, or the week after that? 22.
Date may fix.
Both of us are there.
Is this a bench 5 matter?
Who put it?
Oh,
I'll check. I'll report to you.
Because I don't know. It appears to be. I don't
The
know.
register to verify and put it record.
Okay, right.
But the interim protection be continued in that case.
Right. Mr. S. Banik appears for the petitioner. Petitioners, while Mr.
for respondent 9 May.
K. Uddin appears for point number 9. The council pray that the matter may be listed after the vacation. After
2 weeks time.
2 weeks.
A date may be fixed. In the meeting.
Maybe fixed on. Give a date.
Not sure.
When?
November 20th.
20th November. Registry to verify
The bench.
whether the matter is a bench 5 matter and is the same on the on 20/11/2024 before the appropriate bench.
The interim protection.
Interim order continue till the next.
May I I'd like to mention for listing one admission matter. Last posting 6/9/2000.
Give a date.
My lord, I beg to mention a content matter, my lord. Any day in the next week.
Give a date.
My lord, with the consent of other side, my lord, I beg to mention item number 19, my lord. Engaged counsel for the respondent 3 is under medical treatment, my lord. Therefore,
Who is he?
Mrs. A. Bhattacharya.
Mrs. It has been adjournment prayer has been made on behalf of Mrs.
A. Bhattacharya.
A. Bhattacharya.
Yes.
The counsel for the respondent number.
3.
Out it says P. Kalita.
My lord,
It says P. Kalita out
yes, my in the police Polita is there, but Mrs. A. Bhattacharya is senior.
Bakaladama has been given. Okay.
Yes, my lord.
Counsel for the respondent number 3, who is apparently unwell. This is a matter after
After 4 weeks, my lord.
after 2 weeks.
May it please your lordship.
4 weeks.
4 weeks.
4 weeks.
May it please your lordship. With the consent of other side, I beg to mention item number 28 of the daily list.
Yes.
Your lordship, connected matter is fixed on 12th of November. So this matter may be taken up with that matter. Your lordship.
12th of November.
Yes, your lordship.
Item 28.
Yes, your lordship.
Have you taken the consent?
Yes,
I'm
your
for the
lordship.
respondent.
Okay.
Your
Miss-
lordship, interim order.
Miss
S. Nawar.
S. Newar, learned counsel for the petitioner, feels that the matter may be listed on 12/11. Mr. A. Dhanukar for the respondent number 5 submits that he has got no objection to the same. Accordingly, lead this matter on 12/11.
Your lordship, interim order.
Interim order to continue till the next day. Yes.
With the consent of petitioner, I beg to mention item number 44, my lord. In this case, my instructions are awaited, my lord.
Item 44.
Yes, my lord.
Your father?
APDCL respondent.
Have you
For the petitioner.
here for the petitioner? Mr.
B. Sharma.
B. Sharma appears for the petitioner. Mr.
B does.
B. Das appearing for the APDCL submits that he may be given some more time to obtain instructions and file affidavit. Praise aloud. This is the matter after
3 weeks, my lord.
3 weeks. Interim order to continue till the next day.
May I please your lordship? Your lordship, I beg to mention for listing of a writ petition to come up for admission on 12th of next month.
Okay.
But I'm praying for listing of a new motion matter on Wednesday, my lord.
Tomorrow?
Tomorrow, yes,
Tomorrow.
DPO. May it please your lordship, item number 40 and 41, supplementary list, your lordship. These matters have been listed today. I have the instruction to withdraw the matter, but your lordship have asked for a affidavit to be signed by the client. So may I pray that the matter may be taken up tomorrow, your lordship, by the time it will be get filed.
Okay, right. On the prayer of Mr.
R. Sinha.
R. Sinha, learned counsel for the petitioner, list the matter tomorrow.
Your
40 and
lordship, along
41.
with,
40 and 41.
along with the 2 IAs I have filed today, your lordship.
Along with the 2 applications, IS that the petitioner has filed by filing number dated
12788 and 12799,
Of
2024. Your lordship, the interim will continue till tomorrow.
there is a motion.
Yes, your lordship. there is
Interim
already-
order
no,
to
no,
continue till tomorrow.
Deeply obliged, your lordship.
Please, your lordship. Lordship, I pray for listing of two identical writ petition in the admission column on 12th, my lord.
Okay.
May it please your lordship, I beg to mention for listing on repetition. It was last listed on 11th of March 2024.
Okay, next, give a date.
She was back to mention item 43, lordship, supplementary list. Matter may be adjourned.
Why?
Lordship, conducting counsel is Mr. Puya is not well, lordship.
No, you wait. You wait.
May I please your lordship, I beg to mention for listing lordship. It's a contempt matter, lordship.
Okay, give a date.
May I please your lordship, I would beg to mention for listing of a writ petition. Matters regarding non-payment of.
Give a date.
30.
If I may please your lordship, I beg for listing a fresh matter by tomorrow or by after Diwali. It's a matter related to tender, so. it may
Tomorrow,
urgently come.
tomorrow.
Lordship, I beg to mention item number 33. Lordship, kindly matter may be passed over for review. Senior is out of station.
Yeah, for whom?
I'm for the petitioner.
Why do you want to pass over?
Senior is out of station.
No, you wait. No, not an issue. Not an issue. We'll just see if the respondents are appearing or not. Sir.
One for motion.
May I please your lordship? Lordship, in this matter, lordship has passed some direction to the respondent authority on 20.
Yes, his name is there.
Name is clear, my lord. The payment will be made up immediate after Kali Puja. As per my power bill instruction. Process is going on.
That may not be sure, my lord, at least was.
Now, what to do, madam? I cannot
Actually-
force them to, what can we do? There are so many, persons who have got to have their bills paid.
More than 500 contractors, lease of construction is approved by authority for payment. As per power bill
You see,
instruction, immediate after.
Contempt will lie only when there's willful violation. Now they are saying that they are ready to pay and they've admitted the amount. Only thing they are saying that we don't have the funds to pay right now.
No,
So
no,
they will pay according to
Lordship,
this.
This is not a contempt matter, this is a writ petition, my lord. and
Correct,
earlier
correct.
Petition has filed and they have submitted.
No, this is the second time, correct?
Second time. Yes.
Okay.
On last occasion, they have submitted that a list was prepared by the person and his name was appeared in the serial.
Oh yeah, has been complied with. That's why it was done. Okay.
76.
Yes,
Yes.
this is a different matter. You have got to pay. When?
Immediate after, as per power bill instruction, immediate after Kali Puja.
Immediately
Okay,
after Kali
500,
Puja means in November,
November
in
3rd.
next week,
Next
Next
week.
week.
immediately.
Second week, my lord, at least second week of. I will give the update. instruction.
Okay, right. Mr.
RTM.
R.K. Muchari, 11th Council for the BT submits that as per verbal instructions received by him, the petitioner will be paid his dues immediately after the
Kali.
Kali Puja holidays. Accordingly, leave this matter on. Give a date,
11 November.
11.
11. But the item number 29 and 30 is the same thing.
Item number 20.
29 and
What is the verbal instruction in 29 and?
29,
30 is said by. So
I am not referring.
there,
29
there are some.
Then let us see.
Yes.
Because he's not there. Yes,
As per lordship's direction, I have received instruction from SIC. The person concerned was arrested on 24/10, lordship. Although
Okay.
petitioner has submitted that 15 times MBW has issued, lordship, but he has taken steps only for 4 times, lordship.
Okay, anyway,
Lordship,
so
otherwise,
he has been arrested.
he has been arrested and produced before the judicial magistrate first class landing, Lordship. Lordship, it in page number 5, Lordship. Lordship, page number 5, Lordship. It's submitted there, Lordship. That part.
There's no
That
pagination
no,
here.
no page is given, Lordship. From the first Lordship, it should be 5, Lordship.
1, 2, 3, 4, 5. Okay, out here.
5.
The last part.
Last part, Lordship.
Twenty-four ten.
2410.
3 days after the order passed by this court. So they've done it.
When Lordship, earlier occasion, he was declared the absconder, Lordship.
End of the matter.
Conduct, my lord, immediate.
Mr. Counsel, your only issue was that not arrested. Now you be arrested. End of the matter.
For that reason, my lord, I am not getting maintenance.
You go to the court.
My lord,
Tenants part is not
2019, my lord, I am there.
Mr. Counsel, the issue here, this is not an executing court.
No, my
This is a
lord,
writ
if
petition.
my lord arrested, I have nothing to say, my lord.
That's all. Your only case was that the orders were not being complied with. That's all. Right. Heard Mr. S. Chauhan, learned counsel for the petition. While Mr. K. Gogoi appears for the
I'm for Respondent 1 to 4, Lordship.
respondents number 1 to 4. Pusta. The petitioner's case is that the petitioner had filed, said para 1, last order, para 1 from had filed. Okay, start from there, second line. Then till the second paragraph also you take. Okay, next, third paragraph. Mr. K. Gogoi has submitted a letter dated 25/10/2024, issued by the Superintendent of Police Pajai, Assam, which is to the effect that search warrant, which is to the effect that
NBWS, Lordship.
it is to the effect that on searches had been conducted on several occasions on the basis of 4 non-bailable warrants of arrest issued on 4/12/2022, 6/12/2022, 9/12/2022, and 4/8/2024. On all occasions, the the petitioner's husband was not found. However, the warrant was finally executed on 24/10/2024, and the petitioner's husband has been arrested and was produced before the court of the learned JMFC Wide Lumding PS GDE 34 dated 24/10/2024. Full stop. In view of the fact that the present writ petition is only with regard to non-execution of the named non-bailable warrant of arrest, this court finds that the present writ petition has become infructuous, keeping in view the fact that the said non-bailable warrant of arrest has been executed. The writ petition is accordingly closed. The letter dated 24/10/2024 issued by the SP Hojai is made a part of the record and marked as Annex X. You can take a copy if you want. You can photo with your.
I can.
You can give it. Yes, yes, Mr. Counsel, John. No.
Hello, the matter pertain to one kind of contractual bill, and my similar matter is already fixed.
Okay, right. Mr. S. Chamaria submit that that similar matters have been listed on 7/11. Accordingly, leave this matter on 7/11.
But 3689.
3689. Before that, you're right. Ms. D. Jane appears for
Respondent number 3 and 5.
respondent number 3 and 5, while Ms. Yudas appears for
1 and 2.
1 and 2.
3689.
Item 4.
Make use of it.
in 2023, my lord, the Nagaon Medical College was established. And on 16/2/2023, the respondent number 4 wrote a letter to the petitioner firm, which your lordship will find at page 23, my lord. Page 23. So they write a letter on 16/2/2023, the superintendent, and it says, my lord, sir, with reference to the above mentioned subject, I have the honor to request you to kindly provide dietary service to the indoor patients admitted in all wards of Nagaon Medical College. The terms and conditions for payment of the same service will be similar to that of Tezpur Medical College. Then, my lord, an agreement was executed, which your lordship will find at page 26, my lord. Page 26. This was the agreement between the petitioner firm and the Nagaon Medical College, page 26. The date of the agreement is 3rd April 2023, which your lordship will find at the top, page 26. And if your lordship kindly turns to the next page, page 27, clause 1, it says, the allotment of contract to run the diet section for supply of diet to the inpatients of the hospital for the period of 2 years with effect from 23/2/2023, which would mean that my tenure would expire on the next year. Now, my lord will kindly see.
Expire on 25.
25, my lord, next year. So thereafter, my lord, we commence, and on, if your lordship kindly turns to page 32, your lordship will see, my lord, page 32, they also say, in addition to the dietary services provided to the indoor patients of NMCH, you are hereby requested to provide tea and snack services to the staff of the office of the principal cum superintendent at a very nominal rate on no profit, no loss basis. We do that also, my lord. And on the basis of the agreement, we invest in Nagaon, we set up a working unit. Suddenly, my lord, they issue a tender, which your lordship will find in the next page, page 33. It's dated 8/11/2023. Organization name is Nagaon Medical College and Hospital, and they want to give dietary services. Now, since our tenure was till 2025, we had no reason to, my lord, be aggrieved. We were under the, my lord, belief that the work would commence once our tenure expires, my lord. And there's a comparative statement which was prepared, which your lordship will find at page 42.
So you took part.
I took part, my lord, because I was under the belief that the work will commence after my tenure ends. And if your lordship will kindly see the financial evaluation at page 42, my lord. Page 42.
Yes.
And serial number 1, L1 is the private respondent number 5, and I'm below. Now, the rate which was quoted by the private respondent number 5 was very unrealistic, my lord. It was very low. And at that rate, my lord, nutritious food cannot be provided.
We do not know. That is not right.
I'll show from the documents, my lord. Thereafter, my lord, they approached this honorable court. Since the rate quoted by them was unrealistically low, no work order was issued. They came before this honorable court, and this honorable court issued notice, which your lordship will find at page 45, my lord. Page 45. The second paragraph. Aggrieved by non-awarding of contract for healthcare, kitchen and dietary services for Nagaon Medical College, despite being declared L1, the present writ petition has been filed under Article 226. Issue notice and including notice on the prayer of interim relief. They also file a interlocutory application, which your lordship will find at page 50. Page 50, my lord. The third paragraph. If your lordship kindly notes third paragraph. The present I is filed seeking of stay of communication dated 18/7/2024 issued by the respondent number 4, whereby the earlier contractor has been asked to continue to supply the diet in the hospital through the contractor was not successful in the tender process. At this stage, Mr. So-and-so, the Learning Standing Council of the Health Department submits that the work order is not issued to the petitioner for the reason that the rate quoted by the petitioner is too low, and at that rate, nutritious food cannot be supplied. It is the further instruction of Mr. So-and-so, the Learned Council of the Health Department, that the authorities are having apprehension that at this rate, quality food cannot be supplied. In fact, the matter also came up on 18/9, and on 18/9 also, at page 54, the same stand of the department was reiterated. Page 54, my lord.
Yes.
Initially, it came on 11.9, thereafter on 18.9. Page 54, my lord, the first paragraph. At this stage, Mr. So-and-so, the learned standing counsel of the health department, submits that the work order is not issued to the petitioner for the reason that the rate quoted by the petitioner is too low. And at that rate, nutritious food cannot be supplied. Basically, my lord, predatory pricing. Now, this was the stand. Suddenly, my lord, after the filing of the writ petition, certain private negotiations took place between the private respondent and the state authorities, my lord. And we were not made a party in the writ petition. We were not even made allowed to participate in those private negotiations. Everything happened behind closed door. And this is what happened on the impugned letter. Your lordship will find in the next page, page 55.
Yes.
Page 55. In fact, my lord, before I turn to page 55, I'll just show one paragraph from page 54, the preceding page. The second paragraph. Mr. So-and-so has obtained instructions to the effect that the authorities are interested in having a negotiation with the successful bidder so far relating to the price, inasmuch as according to the authorities, the price quoted by the petitioner may result in supply of poor quality of battery services. Now, they were interested. And next, if your lordship kindly turns to the impugned letter at page 55, my lord. Page 55. With reference to the Honorable Guwahati High Court wide order number so-and-so, a negotiation was held today on 29/2024 at 2 p.m. between the respondent number 4 and the L1 tenderer, Messrs. So-and-so. And if your lordship kindly turns to the next page, page 56, the operative portion is at the bottom, my lord. In view of the above, it is decided that Messrs. So-and-so is to be awarded work contract for supplying diet for patients for 1 year with effect from a date to be decided. With effect from a date to be decided, once the guidance as mentioned in point number 3 above is clear. So they did not, my lord, decide the date from which the tender is going to commence. Now, my lord, we'll see after this order was passed, they closed both the writ petitions and the IA. Page 59.
Both the writ petitions, there was only one. Writ petition.
Only one, and the IA also connected.
So one writ petition, not
One.
both.
Not only one, and the connected IA. Both were closed. Page 59. So they say that there was negotiation, and in view of the above, nothing survived in the present writ petition. Accordingly, the matter stands closed. When we come to know about this, my lord,
Yes.
when we come to know, we approach the authorities. We say, my lord, page 63. Page 63, your lordship will kindly note. We say, sir, as you are aware, we had executed an agreement for providing dietary services to patients in various wards of Nagaon Medical College and Hospital on 3/4. The tenure of the said agreement is for 2 years with effect from 23 to 2023. Despite such, suddenly on 29/2024, a decision was taken by the authorities to award the working question to Sri so-and-so. Therefore, it is a humble request, right? If at all private negotiations were held, we ought to have been afforded an opportunity of hearing.
No, you see, one thing is the rates have not been changed.
Right.
The rates have not been changed. Now, the only thing is that your period will be over in February.
Next year, 2020. That is my,
That's one.
that is my basis.
Yes. In the NIT,
Yes, madam.
is there any clause or provision which states that the supply of these articles, dietary articles, will start from a particular date?
My lord, NIT bid offer validity period is there 180 days, my lord.
180 days.
Yes, my lord, 633.
So-
So, and
But it is for how many years of
it
days?
is for contract period is 1 year, 6 days, my lord.
1 year, 6 days.
Yes, my lord.
But what do you say? Aren't you bound by the agreement that you made?
My lord, but subsequently, my lord, this tender notice has been issued.
Maybe, but this does not say from which date.
Yes, my lord.
You have made an agreement with him.
Yes, my lord. So I will obtain instruction regarding that, my lord.
Okay, right. Heard, Mr.
A.K. Barua, my lord.
A.K. Barwa, learned counsel for the petitioner, who prays that the decision of the respondent authorities to award the work order for supply of dietary articles pursuant to the NIT dated 8/11/2023 to the respondent number 5, as contained in the letter dated 20/09/2024. Should be set aside. And no, before should be set aside, and the decision of the authorities to curtail the tenor of the agreement dated 3/4/2023 should be set aside. Next para. The petitioner's case is that pursuant to a request made by the respondent authorities by letter dated 16/2/2023, an agreement was executed on 3/4/2023 for supply of dietary articles by the petitioner to the patients in the various wards of the Nagaon Medical College and Hospital, Nagaon. The agreement was for a period of 2 years with effect from 23 to 2023. The petitioner was also asked to supply tea and snack services for the staff of the office of the principal, Nagaon Medical College Hospital, on a no profit, no loss basis, while letter dated 27/7/2023. Full stop. Next para. The respondent authorities, however, issued an NIT dated 8/11/2023 for supply of dietary articles by full stop. The petitioner participated in the same, and as per the comparative statement, the respondent number 5 was L1, while the petitioner was L2. Full stop. As no contract was being awarded to the respondent number 5, the respondent number 5 filed WPC 1878/2024 along with IA Civil 2612/2024. The stand of the respondent authorities in WPC 1878/2024 and 2612/2024 and IA 2612/2024 was that the work order was not issued to the petitioner due to the reason that the rate quoted by the petitioner was too low and that no nutritious food could be supplied at the said rates quoted by the respondent number 5. Despite the above, a negotiation was held between the parties and by letter dated 20/09/2023, it was issued by
Respondent number 3.
respondent number 3. The respondent number 5 was awarded the work order for supplying dietary articles to patients for 1 year with effect from a date to be decided by the respondent authorities. Consequent to the above, negotiations, WPC number 1878/2024 and IA Civil 2612/2024 was close. Full stop. Next para. In view of the negotiations held between the respondent number 5 and the respondent authorities, comma, the petitioner wrote a letter dated 21/10/2023 informing the respondent number 3 that the tenor of agreement made between the respondent authorities and the petitioner was for 2 years, and as such, a request was made to recall the letter dated 20/09/2024. Next paragraph. The petitioner's case is that the petitioner's agreement would only expire on 22/2/2025, and as such, till the said date, no contract could be executed by the respondent number 5 in pursuance to the NIT dated 8/11/2023. Issue notice returnable in 4 weeks. Mr. R. Bora,
DP, brother.
DP Bora, accept notice on behalf of
1, 2, 3, and 4, my lord.
respondents number 1 to 4. Petitioner takes steps for service of notice upon the respondent number 5 by registered post with AD within 3 days. This is the matter after 4 weeks. This court is of the view that the matter requires further consideration to stop as such till the next returnable date, comma. Status quo as on today may be maintained, should be maintained.
Public. DP. DP.
Yes,
Your Lordship, the petitioner had in earlier occasions applied for arms license.
okay, we'll issue notice that time. Heard, Mr.
I say.
Huh?
I who say.
I Hussein Leonard, counsel for the petitioner who submits that the petitioner's application for issuance of a arms license what have I said? Had been rejected. The petitioner had earlier filed WPC number 2072/2021, challenging the rejection order dated 1/11/2022, passed by the Deputy Commissioner Kamrup M. Pustak. The said writ petition was closed by an order dated 19/8/2024, by granting liberty to the petitioner to challenge the impugned order dated 1/11/2022. Pustak. So so did you,
In the earlier occasion, Your Lordship, writ petition, Your Lordship. Actually, I applied for the arms license, but nothing was answered to me. That's why I filed a writ petition. During the pendency of the writ petition, this order was passed.
okay,
Thereafter, the writ petition was closed, providing me liberty to challenge this order.
then,
Your Lordship, thereafter, I am before this honorable court.
oh, challenging here.
That.
What have I said? No, before that. Not having been decided by the respondent authorities, comma, the petitioner filed WPC, cut all that, cut everything. The petitioner filed WPC number 2072-2021. During the pendency of the writ petition, the Deputy Commissioner Kamrup M issued the order dated 1/11/22, rejecting the petitioner's prayer for grant of an arms license. WPC 2072-2021 was closed to provide order dated 19/8/2024, giving liberty to the petitioner to challenge the impugned order dated 1/11/2022. Sub issue notice returnable in 4 weeks. Ms. Udas accepts notice on behalf of
All right.
all the respondents. This is the matter of the 4 weeks
Extra copy.
to enable the respondents to file their affidavit. Extra copies of the writ petition be provided to Ms. Udas within 2 days.
Obliged.
When did you complete the contract?
2022,
Heard, Mr.
DC Kalita.
DC Kalita, learned counsel for the petitioner who submits that the petitioner's contractual dues amounting to rupees 28,19,657 has not been paid. Issue notice returnable in 4 weeks. Mr. S. Datta appears for
1, 2, 3, and 7.
1, 2, 3, and 7. Mr. D. Bhattacharya for 4. While Ms. Udas for 6, 9, and 10.
8 also, my lord.
Yes, that's for 8 also, huh? Yes,
1,
Datta for
1, 2, 3, 7, and 8.
7. Okay.
And 13 also. Sorry, my lord, next page.
13 also, okay. List the matter after 4 weeks to enable the respondents to file their affidavit. Extra copies be provided to the counsel for the respondent during the course of the day.
Obliged.
What is to be done?
Let the notice go, my lord, I will,
Okay.
because he is here for the part payment, my lord. The payment has been made.
Mr. Mr. P. Bora, learned counsel for the petitioner submits that the TO Autonomous Council has not been given their entire contractual dues.
My lord,
Issue notice returnable in 4 weeks. Mr.
S. Neogi.
S. Nyogi accepts notice on behalf of all the respondents.
All.
List the matter after 4 weeks to enable the respondents council to file affidavit.
Right.
Obliged.
Item number 7, I am for my lord, respondent number 5 and 10.
In item 7, be over for
PWD and finance, 5 and 10.
5 and 10.
Yes.
Miss you asked for 6 and 9 only, huh? And
Item number 11.
yes, what is the case?
I'm on a very thin line of.
Huh?
We have participated in a tender process.
Yes.
Which was evaluated for the technical evaluation was carried out. It started on 29th of August and ended in October 17, Lordship. In between, they have intimated us certain shortfalls on it and bid document, Lordship, which was sent via emails, which were not received by us. Eventually, we came to know and we have represented on 5th of October 2024. They have ignored the representation and evaluation results were declared, Lordship. So our prayer is that our representation and we may be allowed to give our clarify our shortcomings so that our bids for the price are open along with other bidders, Lordship. As of now, the price bid has not been open.
No, but then if they'd asked you to rectify your defects,
They have done that, Lordship, but the emails were not received and we have represented.
then I do not know then whose fault is it?
Lordship will kindly take up the
Technical
procurement
evaluation,
Huh?
the technical evaluation opened on 29th of August 2024.
That's
itself,
correct,
Your Lordship.
Technical, just a minute.
NIT is 26th of June 2024.
Technical evaluation done on
After 29th of August
after
2024.
29th, when was it done?
It was started on 29th of August and it was
It was
ended
open.
29 August 24 till
17 October 2024.
17 October 24.
Results were declared on 17. So eventually they have emailed us, sent us asking for this, fulfilling the shortcoming lordship in September, which are not received. And we have represented on coming to know about those emails from them. We have represented on 5th of October before the results were declared.
These are questions of fact. You do not know.
Lordship, this is part of the record. They have responded in another representation that we filed after the bids were declared. They have replied to that they have not replied to 5th of October 2024 representation because it was filed after the
What was filed after what? What are you talking? I don't know. You're confusing me.
Lordship on September 13th and 18th. They have emailed us and asked for the documents to fulfill the documents, Lordship,
Then
which emails were not received by us. Eventually, on 5th of October, we have filed a representation before the tendering authority, seeking a permission to submit those documents and asking for details what are the shortcomings.
but when did you come to know of those emails?
On 4th or 5th, Lordship, immediately we have filed because
On 4th of October, you got to know.
October, Lordship, and 5th itself we have submitted.
This, I don't know.
And Lordship, what the procurement policy of government says, any verification has to be sought by written document and it has to be sent by post, Lordship. I'll just take your Lordship to that. Copy the details. Copy the details. Lordship, I flagged the page, Lordship.
What does the tender document say about the
It's
clarification?
Online or offline. They have slashed it online/offline.
Then,
But now, Lordship,
if it's a e-tender, where's the question of written
they have not uploaded in
clarification?
the website also.
Huh?
They have not uploaded in the website. They have sent us an email which was not received by us. We acknowledge that we did not receive it. We went before them or before the results were declared.
No, what does the tender notice say? That how is the clarifications to be asked for, not this procurement? This is not, you have
It is page
sentence here.
32.
Huh?
Page 32, Lordship. Two point 8.1, Lordship.
Huh?
The AC is the evaluation and comparison of bids. The employer may, at its discretion, may ask the bidders for clarification of the bid. Clarification or response from the bidder shall be in writing. The clarification will be asked offline/online, and the clarification and response of the bidder shall also be online/offline as applicable. Lordship. Lordship will kindly see our
The
representative.
second clause also, Lord.
Hmm?
Second clause also, the employer does not bind himself to accept the lowest order tender. Any
That is
tender
not yet. We
It's
have
not
not
yet
there.
come.
Not on the bidding.
not
So won't the sending of the clarification to your through email, won't it be online? Can't it be sent
Lordship,
online?
we agree to that proposition, Lordship. However, Lordship will kindly come to page 192, that representation that we have filed. Page 192, Lord.
Yes.
So that is the representation we filed. Once we came to know, emails were sent and we did not receive. We say that we express our profound apologies if any caused to the tendering authority due to an unforeseen technical error which led to non-communication of shortcomings. Then we pray it is requested to kindly allow us to establish our eligibility if any shortcomings are in non-compliance as per the tender procurement. It is assured that any relevant document required will be sent within short duration through emails or any preferred media as required by you. We request you to update our shortcomings, if any, give us time to submit the details. That was on 5th, Lordship. Now on
Okay, it was prior to the.
evaluation.
Thereafter, Lordship may come also to our reply, Lordship, the reply by the respondent number 3, Lordship.
Yes.
That is at page 196.
197.
196.
Yes.
197, Lordship.
Yeah.
Lordship, it is the reply to the previous page, Lordship, by the respondent number 3 to the petitioner, Lordship. In response to letter dated, the standing committee has gone through your request and response of key issues as mentioned in the letter are as under. Number one, the technical bid was obtained on 29th of August 2024. And after evaluation of the technical bid, the shortfall document were asked to you on so-and-so mail. That is the mail that is reflected in his bid.
Lordship, the relevant point will be 0.5, Lordship. That is with regard to.
Just a minute. Let him read. Let him.
on 13/9/2004 for kind submission with last date of 18/9/2024. When no information were received from your side by 18/9/2024, then a reminder of the same was also sent with deadline of submission of on 19/9/2024. Also, a representative called on the mobile number providing the bid and called was not responded. As your responses were not received till last date of submission of the shortfall documents, hence the bid was technically non-responsive. We received your letter number so and so dated 5/10/2024 via email while period of submission of clarification was over. In the letter, reason for non-submission of clarification, that is unforeseen technical error from your end, is already mentioned by the petitioner therein. As such, receiving documents after closing date is against the tendering procedure and transparency in the procurement. In the letter aforementioned, in the petitioner is mentioned completely new official email ID and contact numbers, while tender committee was sent the letter of clarification on the following email and mobile number mentioned in the letterhead of the petitioner along with bid documents. This is the mail, this is the phone number that was reflected in this bid document. After that opening of the financial bids of successful bidder, the auto-generated messages were received by you through CPP.
So financial bids have been opened.
Yes. Your statement in the letter dated so and so is not correct. The standing committee has completed the tech evaluation within 5 minutes and sufficient time was not given to the submission of the shortfalls. The standing committee was given for sufficient time, 5 days for clarification submission from your end. Standing committee has not taken has taken almost 3 weeks in evaluation of all bids since opening of the technical bid on 29/8/2024. Please also notice that the letter issued from your side having dated 17/10/2024 but signed by you on 16/10/2024, which seems to be incorrect. Lordship may come to the next page, Lordship, that is the annexure, Lordship, where the respondent number 3 has substantiated that on September 13 he was communicated. On September 18 he was communicated. Even on September 19 he was communicated. On the same email that was reflected in the bid document. This is the same email.
What is the last date of submission of the clarification?
It's the Lordship. It was eventually modified. It was not as per. Last date of submission of bid is 17/7/2024, Lord.
Where do you get that?
Lordship, page 19.
90,
Page 19.
19.
Page 19, the last date of submission of bid.
No, not last date of submission of bid.
Lordship.
Clarification.
Lordship, that is 19th of September.
Where do you get that?
It is in the email, Lordship, in the last page. Very last page. Lordship will take the second.
Where are the emails?
At the very last page, Lordship.
Where are the emails?
That is the last page, dear sir, with reference to your technical bid for tender so and so, dated 25/6/2000, you were again advised to submit balance document desired by you by 6 p.m. That is tomorrow by 19/9/2024, Lordship.
Now, how do you justify?
May I draw your Lordship?
How do you justify?
Only 2 points, Lordship. I'll address your Lordship only 2 points. So this point number 5 first. The rejection of 510 representation was done on 21st of October. That is after the technical evaluation was carried out.
Huh?
The point number 5 of page 197. Lordship.
Yes,
We received the letter, they have received the letter, the representation that we filed. They have not rejected before the bids were opened, Lordship, or declared, results were declared on 17. They
what
have-
does it matter? They've given
Lordship,
you a
we have an
time.
Had that been?
No, please, before you answer, you see, I have a few questions. If you don't want to answer, clear my questions, well, that's a different thing. My question is this. In this in the last two lines of the page 197, please read.
Lordship.
In the aforementioned letter, MS Niami Enterprise is mentioned completely new official email ID and contact number. While tender committee was sent the letter of clarification on the following email and mobile number mentioned in the letterhead. So you have been, you now, what is wrong? If you did not receive, because you have got some completely new ID that you're using.
So, Lordship, it may not be entirely correct that they have, the only email was given. Lordship will kindly come to page 193. That is the auto-generated email which was received after the bids were offered. That email you have received, Lordship, that email is a different email. So we had two emails, Lordship. 193, that is coming from the website that where we have submitted our bids, and that emails we have received, but that both emails are different, Lordship. While we agree that emails were sent which we did not receive, we represented on due time, Lordship. We are only seeking opportunity that we may be allowed to submit our.
That is up to them. They are the authors. It's
Absolutely, Lordship.
them.
However,
When they have sent you when they have sent you documents, letters saying that please rectify your bid and you are not rectifying it, then if you take that excuse that you did not receive the email, then what will happen? Everyone will do the same thing later on.
however, we represented before the authorities, before the bids were evaluated finally, Lordship. That was on 5th of October. And they have not rejected or not.
Any representation made by you?
Yes, Lordship.
Where is the representation?
Page 192, Lordship.
That is the one.
Fifth
So
October.
they have rejected it.
Because it is after evaluation.
I don't find any case.
And Lordship may also, if I'm subject to correction, Lordship, page 32, Lordship, might draw your attention to page 33. Subject to correction, Lordship, there is a clause, Lordship, 2.9 evaluation of tenders.
Yes.
2.9.1, the employer shall evaluate the bids in respect to the substantive responsiveness of the bid or otherwise. The employer shall carry out detailed evaluation of the substantially responsive bids. The employer shall check the bid to determine whether they are complete, whether any computational error has been made or required securities have been furnished. Lordship, these are few of the conditions, Lordship, that was laid down, Lordship, but there is no condition that that we are not obliged that we are bound to communicate with them, Lordship. There is no such clause in the tender.
We are not disputing, they have not communicated. Only thing we did not
This is
receive.
council. This is a contract matter. Then
The only thing is that.
public interest is involved.
So had they rejected the representation of 5th of October, we probably could have come before Lordship, before the technical bids were evaluated, Lordship. They have not done anything. They have only responded after the bids were evaluated and the results were declared. The 5th of October representation remained as it is until the bids were evaluated. And once we came to know the emails were sent, we have represented saying, allow us time to submit those documents, which they have not done, Lordship.
I don't find any case.
Though they have the actual authority to decide, the discretion they have discretion to ask for the clarification, they have utilized, they have used that. We acknowledge that they have sent the emails. However, we did not receive on time, Lordship. That was the difficulty. we
And
had.
that is your problem.
But also,
If you did not receive on time.
Lordship will kindly take up the procurement policy, which is the basis of the procurement, that book I have given that, Lordship. The policy of the government of India, which says it has to be communicated by post, speed post or registered post.
No. But this is what kind of a e-tender, correct? And your tender documents have to be submitted online.
Yes, Lordship.
Then this has to be done by writing.
Lordship,
How do you justify clause 2.8.1?
Lordship, that I have to constitute they have the option of online and offline.
Then the 2.81, you have not put a challenge, you have not challenged it.
No,
This allows them to submit their letters online.
Yes, Lordship.
Then at best I can issue notice, that's all, nothing else beyond that. Right. Right, Mister
D dekha, Lordship.
DJ Dekha,
D dekha.
D Dekha.
Yes, Lordship. D dekha.
Have you filed Vakaratnama?
Yes, Lordship.
Learned counsel for the petitioner who submits that the petitioner had submitted his bid against the tender dated 26/6/2024 for bracket construction of EMRS bracket Eklavya Model Residential School bracket close at 0-Roman 2, village. Why is this filed here?
Is it because the tendering authority is in Guwahati and tender process was evaluated in Guwahati itself?
Response number 3 is a.
Tendering authority.
Your Lordship.
This is done in Guwahati. Why shouldn't it be done in Arunachal? It's for construction there.
Yes, Lordship, but they have carried out in Guwahati. It's online mode and their office is in Guwahati. Every communication is from Guwahati.
Same.
At 0 village, so in the synopsis is there, huh? First up. Oh, okay. The tender was a two-tier tender where bids were to be submitted in two parts, that is technical bid and financial bid. First up. Next para. The petitioner's technical bid was, however, declared as unresponsive at the technical bid evaluation stage. The grievance of the petitioner is that the petitioner did not get a chance to rectify the shortfall in his bid documents, although rectification had been allowed by the state respondents. Next para. The petitioner's counsel submits that the respondent number 3 had issued emails seeking clarifications on 13/9/2024 and 18/9/2024. Full stop. However, as the petitioner did not submit any reply to the emails, the petitioner was not allowed to rectify the shortfall in his bid document. Full stop. Though the petitioner came to know about the shortfall on his bid documents on a later date and had sent a representation dated 5/10/2024 to the respondent authorities, informing them that he had not received the emails and had sought to correct the defects, the same was rejected by the respondent authorities by the letter dated 21/10/2024. The petitioner's counsel submits that the declaration of the petitioner's technical bid as unresponsive had been made on 17/10/2024, that is after 5/10/2024. Pustak. As such, the petitioner should have been given some more time. Should have given some time to rectify the defect in his technical bit. As the final decision rejecting the petitioner's bid, technical bid, had been made only on 17/10/2024. That's your case?
Lordship.
Pustak. So what do? We issue notice, that's all. Actually, I don't find any key.
If the financial bids are open, I will not have a case anyway.
Huh?
So if the financial bids are open, eventually without giving me an opportunity.
No, I don't know why it should be allowed. Why? What is what? What is wrong? This is basically a contract matter.
Yeah.
Where is your right?
Only thing, we are only praying for an opportunity to rectify, though still we have a time and they did not. reject it. They did not receive the representation before the technical evaluation was carried out. Only after evaluation was carried out, they have rejected on our prayer, making an application after the evaluation was done. Had they considered on 5th of October, probably, and the informative, the minor informative as.
Right, Mr.
DJ Das,
DJ Das, the learned counsel for the
CEC Lordship for 1, 2, 3.
for the response number
1, 2, 3 Lordship.
1 to 3 submits that the technical bits of the tenderers were opened on 29/8/2024. And a final decision on the technical bits were taken on 17/10/2024. As the respondents had found shortfalls in the bid of the documents of the petitioner, emails dated 13/9/2024 and 18/9/2024 were issued to the petition. No, just email dated 39/2024 was issued to the petitioner, asking him to rectify the shortfalls in his bid document. However, as the same was not done, the petitioner was issued another email dated 18/9/2024, asking him to rectify the defect by 19/9/2024. The representative of the petitioner was also called on his mobile number provided in the bid, which was not answered. It was not responded to. As no response had been received from the petitioner, till the last date of rectification of the bid documents, that is 19/9/2024, the bid was declared technically non-responsive. He also submits that the petitioner's letter contained completely new official email ID and contact numbers, while the tender committee had sent the letter of clarification on the email IDs and mobile numbers mentioned in the letterhead of the petitioner, along with the bid documents. He also, the counsel for the respondents also submits that in terms of clause 2.81, 8.1, 2.8.1 of the NIT, comma, the employer may at his discretion ask the bidder for clarification of the bid to assist evaluation and for comparison of bids. The clarification and response from the bidder shall be in writing and would be asked offline/online. And classification and response from the bidder should also be offline/online, comma, as applicable. The also for the response submits that when the petitioner has failed to submit, so has failed to rectify the shortfall in his bid documents as communicated by 2 emails, comma, the petitioner can have no right to have his technical bid evaluated. Correct? So, we'll list it again. First day, so thick also. Issue notice returnable in 2 weeks. Mr. DJ Das, accept notice on behalf of all the respondents. This is the matter after 2 weeks.
Much of the language.
Given this.
Yeah, we lost it.
Yes, what is this?
The case is the petitioner is a chemist. He is employed in the authority of the respondent authority. And he's now this contract is going on, existing contract is going on. It will be end on December. There is a written contract between the both parties, and there is a specific clause where the look in that is page 31.
So he's been rejected.
Yes.
Page?
Page 31, Lordship will find. Page 31, Lordship will find the period of contract, Lordship.
I know 3 years plus 1 year. Correct.
That is the period of contract. Yes, it's extension to the 1 year.
That's so that 1 year extension has been rejected.
Rejected. And that was challenged by this.
Now you're challenging it.
Yes.
So let us see what part of the rejection order you're challenging.
Yes, Lordship will find. That is why Lordship I will first come to that clause, page 31.
Yes.
Page 30.
Yes, it says sole discretion, so it has been rejected. So
Yes,
now,
sole discretion, Lordship.
now let us see the rejection. Let us see the impugned order, the impugned letter, page.
Impugned order, Lordship find is 135. 135. And extra 18, 135. Directly, the first two paragraph was the history of this, that is not so much relevant. Directly come to the page 36.
Yes.
Second paragraph.
Yes.
Finally, it is extremely important to the context is not extendable ordinary after it was. They have used it as there is some extraordinary situation. Now, Lordship will find my submission is that if a written contract is there.
Okay, anyway, we'll issue notice. Okay, right. Heard, Mr.
They filed an affidavit on that.
Heard, Mr.
P.B. Barua.
P.B. Barua, learned counsel for the petitioner who submits that He is having an existing contract as an authorized local chemist under the central government health scheme till 16/12/2024. Full stop. The further case of the petitioner. Actually, it's page 133, para 3. Okay. Okay, then take 134. No, then you next you write. No. Next para, you write as in that para 3, the last 5 words you say writ petition number 5294/2024 was filed by the petition. Okay. Full stop. Next para, you write. Page 134, para 4. Huh? Then out here in this para 4, you say this court is order dated 8/10/2024. That is there. Yeah. In WPC number 5294/2020. Then everything will be same. Then right. Next para. During the proceedings of WPC 5294 of 2024, the respondents submitted the order date, impugned order dated 18/10/2024, issued by the additional director CGHS, Guwahati, which is to the effect that the prayer for extension made by the petitioner could not be granted. Good. The petitioner has thus, next para, the petitioner has thus prayed for setting aside the impugned order dated 18/10/2024. Okay. Then you write next. The period of contract of the petitioner as an authorized local chemist is governed by clause 12 of the Act. Clause 12 of the
NID,
NIB, NIT,
page 24.
NIT at page 31. Huh? 12 is there. Okay, that's issue notice returnable in 3 weeks. Mr. CKS Barwa accept notice on behalf of all the respondents. This is the matter after 3 weeks to enable the respondents to file their application. Extra copies of the writ petition be provided to the council for the response. What is to be done here?
One bill was raised, as per
Just a minute, 1 minute.
kindly see order dated 8/6/22, 8/6/22, everything will be clear, my lord.
Yes, what has happened to the police case?
My lord, that my lord, 22-6, my lord, lordship may kindly see. My lord, I have supplied the order also, my lord.
22-6.
My lord, that next order, my lord. 22-6, my lord. My lord. Yes, my lord, before my lord.
22-6.
22-6, my lord, 2022, my lord. My lord, the order dated 4/10/2016, my lord, it was there, my lord, enclosed there, my lord, whereby, my lord, the case, my lord, criminal case, my lord, pending against me, my lord, after payment of all dues, my lord, was closed, my lord. The order is there, my lord, in the file, my lord.
Which one? 4/10/2016.
Yeah, exactly, my lord.
Yes, what is to be done here?
And my lord, this is a letter, my lord, written by them, my lord, to the officer in charge, my lord, Electricity Special Police Station, my lord.
Saying what?
Saying, my lord, that all payment has been due, my lord, matter may be closed, my lord, police case may be closed, my lord.
The issue is now slightly different. Well, the assessment that was done under 126, which traveled up to 127 before the appellate authority, and the FIR that was registered under 135, they are separate proceedings altogether, my lord. They can exist simultaneously and they have no bearing on each other. There is a judgment of the Honorable Supreme Court, which has also been referred to by our coordinate bench of this Honorable Court. There is a judgment to that effect. So the assessment, the liabilities, and all flowing from the
So 126 and 127 was with regard to unauthorized use or with regard to theft?
theft of electricity, and 135 is with regard to filing of an FIR for theft of electricity. But the civil liability is for the loss of revenue due to theft. That has to be ascertained under 126, which is again appealable.
That has
under
been
126.
paid. That has been paid.
That has been paid.
126, 127 has been complied
Yes.
with.
And my lord, that my lord, case was
Just
also
a minute, Mr. Counsel, why? I'm
Mr.
talking to him.
Yes. Now, what has happened is there was an assessment that was carried out. It was challenged before the appellate authority. The appellate authority fixed it, said that the amount has to be ascertained within that a certain
Reassess.
perimeter. Yes. Now, thereafter, my lord, what had happened was the Accountant General, Assam, had carried out an audit, and they found that the assessment was erroneously done, and for reasons of which we were directed to enhance the amounts. So for that very reason, we have revised the bill and given them an additional bill for the very same period. That is the issue before my lord.
Oh, okay, so your assessment was wrong.
Yes.
So the reassessment is the issue, whether he has to pay or not.
Yes.
lordship may kindly see now, my lord, section 127, my lord. Yeah, after my lord, that my lord, after 127, my lord, nothing can be done, my lord. And they have.
120 is in the 127 order. Did the appellate forum
Yes, my lord.
quantify the amount payable by you?
Yes, my lord.
Quantified?
Yes, my lord. Lordship may kindly see, my lord. My lord, that it is, yeah, my lord. We have paid, my lord, everything, my lord. But, and my lord, before preferring the appeal, my lord, we have to pay the 50% of.
That is a different issue.
We have paid 15%, my lord. And whatever, my lord, the total amount, what, my lord, the appellate authority has given, it is less than, my lord, the half of the amount, my lord. So, my lord, there are, my lord, additional payment, my lord, we have made, my lord. That was adjusted against the, my lord, subsequent bits, my lord.
The appellate forum has done what?
My lord, before I going to appellate forum, my lord, we have to pay, my lord.
That might have 50%, yes.
So, my lord, already we have paid, my lord.
Correct.
The assessment made by the appellate forum, my lord, is, my lord, less than the, my lord.
That less than the deposit.
Yeah, exactly. So, my lord,
So you have to get back money.
yes, my lord. My lord, that will be adjusted, my lord. That we have nothing to say, my lord. The police case was.
So now, okay, now his case is that the assessment made on the basis of which you had taken recourse to 127, that was wrong. Is it?
Yes, yes. But yes,
that will be a never ending exercise.
my lords, because there was an objection raised by the Accountant General, my lord. The period remains the same. period has remained the same. The assessment, the formula that had been adopted while making the calculation, that was found to be erroneous. So we had to revisit the calculation, but the period has remained the same. So there is a disparity of now 2,87,000. So that is the revised bill that is under challenge.
My lord, as per section 127, my lord.
And that 2 lakhs so and so.
Yes.
Prior to making the revised bill, the earlier bill has been challenged, and the amount has been lessened.
Yes.
Now
Not lessened, my lord. The period has been ascertained.
period is the same.
Yes.
But the rate of assessment is different.
The
Quantification is different.
yes. So
Let us see, how much
Yes,
was the final assessment bill?
yes, my lord. If I may just take my lord's, if my lord's kindly takes up the petition, my lord. The order of the operative part of the appellate authority's order, my lord, page 24.
Yes.
The appellate authority, after going through all the arguments and documentary evidence, became sure that malpractice in the meter was committed. But as the TNC division inspected the metering system on 12/11/2013 and found okay, the penalty is imposed from the date of second inspection, that is 27/8/2014, and not from the date of covering of the meter. So
Mr. Counsel, what are you saying?
yes, it has not been asserted.
He has not quantified the amount payable. Why?
My lord, kindly see the next page, my lord.
Next page. Okay.
This is the revised pay amount, my lord.
But this is issued by us.
My lord,
No, Mr. Counsel, you are giving a wrong information to this court. That's what I was taking a different tangent altogether.
no, my lord.
You see, the appellate authority has not quantified the amount payable by you.
Yes, my lord.
And you said, no, it has quantified. That's what you
No,
told
my
me.
lord, what happened, my lord, after the bill?
Mr. Counsel,
My lord,
has the appellate authority told you that you should pay a certain amount of money?
my lord,
Has he told you in the order? Just tell me the order.
my lord, last line, my lordship, may kindly see, my
Yes.
appellate authority, after going through all the argument and documentary evidence, becomes sure that malpractice is in the meter was committed, but as the TNC division inspected the meter system on 12/11/2013 and found okay. So the penalty is imposed from second inspection, that is 27/8/2024, and not from the date of covering period, that is 5/3/2013. So IRCA should prepare the new bill, my lord. Direction was issued. Prepare a new bill and no surcharge should be levied. And if the penalty bill amount is less then already paid bills should be adjusted in future. This is the direction, my lord.
So, Mr. Counsel, please understand. You didn't understand my question. Till now, you're not understanding my question.
No, my lord, it's not quantified, my lord.
Say that. That is what I asked you.
My lord,
In the beginning, when I said, did it quantify? You said yes. And that took me on a wrong, different path. So now you are saying that on the basis of the appellate authority order,
Yes.
some bill was
Yes.
made.
Yes.
Now that bill,
Yes.
he has paid that bill.
Is paid.
Now, subsequent to paying of that bill, you have found that bill was incorrect.
Yes.
Correct? That's the issue.
Yes.
now lordship may kindly turn to page 34, my lord.
Just a minute. So the issue is whether there was a wrong calculation on the bill, first bill. That's all.
Yes, ma'am.
That's the small, long and short of it.
Lordship may kindly turn to page 34, my lord. My lord,
Look, I am
Section
not,
56.
I am not going into the issue of what is the way it should be calculated or not calculated right now.
my lord, section 56 to subsection 2 says, my lord, notwithstanding anything contained in any other law for the time being enforced, no sum due from any consumer under this section shall be recoverable after a period of 2 years from the date when such sum become past due, unless such sum has been shown continuously as recoverable as area charges of electricity supplied, and license shall not be cut of the supply of the electricity.
This is a different issue.
So, my lord, after 2 years, my lord, my only contention is, my lord, they cannot raise the case after 2 years, my lord.
No, this is a different issue. Completely different issue. Let me see the bill made on the basis of the order of the appellate forum.
Page 25, madam.
So, Mr. APDCL Council.
My lord.
Now, this page 25 is the bill made on the basis of the appellate forum decision?
Yes, my lord. Then page 26 thereafter is the
Is the
statement.
corrected one?
Yes.
26 is the?
Statement of assessment, my lord, with all the breakup, my lord.
Okay, then where is the corrected?
Yes, my lord. The enhanced bill, my lord, will find the revised bill rather, my lord. I report it, my lord. Yes, ma'am, at page 28.
28 is the revised bill.
Yes. Revised assessment bill.
Revised assessment bill. Okay, now, how do we know that you have made a mistake in the first bill?
Yes, my lord. The affidavit in opposition, my lord. Annexure 5, page 14 of the affidavit, my lord, is the draft
Annexure
paragraph.
5, page 14.
Yes, my lord. This is issued by the audit office, my lord.
Yes.
Accountant General, my lord.
Yes.
The bottom paragraph, my lords. Page 14. 2 instances of tampering of meters which was tantamount to theft of electricity under section 135 were noticed. However, the consumers were billed in violation of the above clauses of AERC as described in the subsequent paragraph. Paragraph A thereafter, my lords, is with regard to Messrs. Sri Sanyaji Ispat, which is item number 30. And para B, my lords. Item number 30 is an identical issue.
Anyway, I'm not on that.
Yes, madam. Para B thereafter, madam.
Yes.
Similarly, during inspection in the premises of Messrs. Shivaloy, so the officials of the company found that the consumer were drawing power by tampering the meter. Company officials noticed that the front meter cover was not original along with so-and-so in the meter. Accordingly, the company served September 14 an assessment bill amounting to so-and-so for a period of 18 months from March to 27 August 2014. Agreed by the assessment bill, the consumer preferred an appeal before the appellate authority of the company. The appellate authority confirmed that the meter tampering was done by the consumer. The appellate authority, however, directed the company to revise the bill from 12 November 2013 onwards, being the date on which the inspection team of the company visited the consumer premises and found the meter all right. Accordingly, the company revised the so-and-so assessment bill to 19 so-and-so. Based on the average consumption from the month of August to November 2012, the same was included in March 2015 in the monthly bill of the consumer and recovered accordingly. In both the above cases, audit observed that the method adopted by the company for calculating the assessment bills was irregular. It may be stated that while making the assessment, the basis of average consumption was applicable in the case of incorrect or stop meter, clause 4.2.2.4, where there is no malafide intent on of the consumer. In the inherent cases, the tampering of meter, which was tantamount to theft, were willful acts on the part of the consumer. Hence, the provision of clause 5.A.4.4 of the AERC, which provide for assessment of consumption in case of theft of electricity, were applicable in these cases. Hence, the company should have preferred the assessment bill of so-and-so to Messrs. So-and-so and 0.83 crores to Messrs. Shivaloy Steel instead of so-and-so, which were calculated on the basis of average consumption. Thus, due to irregular assessment of bills in contravention of the AERC rules, the company suffered a loss of so-and-so claim.
Okay. So the method of calculation was one. And they had applied 4.2.2.4. It should have been 5.8.4.4. Yes, so that's the long and short of it.
Malad, thing is this, Malad, but the facts remains, Malad. Malad, when Malad this bill was raised, Malad, as per the direction of the Malad appellate authority, if bill was raised in.
No, the appellate authority order was dated.
Dated, my lord, 18/9/2014, my lord.
18/9/14.
My lord.
And this bill was made when?
23/9/2014.
Bill was 23/9/2014.
No, my lord,
Ah.
the appellate authority's order is 25th March 2015.
When? 25th?
March of 2015.
He's giving me all different things.
Malab,
25th March 2015.
15. Yes.
And the bill was dated?
The bill is dated, my lords, 28th March, 28th March
28th March 2015,
15. Ma'am.
just 3 days later.
No, ma'am.
है ना? 3 days later.
No, it is 25th July 2007. Yes.
25th
The
July.
after the audit, the bill, revised bill in question is of 25th July 2017. And the bill that was raised pursuant to the order of the appellate authority, my lords, is 28th March 2015.
28 March.
28th March 2015.
Yes, madam.
And the revised bill
Yes.
is 28 July,
25th July 2017.
25 July 17. Okay. So the 2017 matter. Yes, you are saying with the 2 years where
Yes, madam, page 34, madam.
this
Section 56, subsection 2, madam.
yes,
May I read, madam? Notwithstanding anything contained in any other law for the time being in force, no sum due from any consumer under this section shall be recoverable after the period of 2 years from the date on when such sum become past due, unless such sum has been shown continuously as recoverable as area of charges for electricity supplied, and the licensee shall not cut off the supply of the electricity.
that's all. Yes, anything?
Well, if I have to respond to that point that he's raised, madam, may I just raise these two judgments, madam, for my lordship's consideration? The very same issue before the Honorable Supreme Court, my lord, with regard to application of 56(2). Para 10, my lords.
In which one? In
In the
2021?
Yes, my lord, Prem Cotex.
Hmm.
Para 10, my lords. It refers to earlier decision in Ramanatullah Khan, my lord.
Yes.
The issues are culled out, my lord. 3 issues arose for the consideration of this court. However, what is the meaning to be ascribed to the term first due in section 56(2) of the Act? In the case of wrong billing tariff, so and so, so and so, my lord. The para 11 thereafter, on the first 2 issues, court held that though the liability to pay arises on the consumption of electricity, the obligation to pay would arise only when the bill is raised by the licensee, and that therefore electricity charges would become first due only after the bill is issued, even though the liability would have arisen on consumption. So that is the point that I did, mother. So the question of with regard to limitation of 2
So
years.
that has already been consumed.
Yes.
So
Malak, it would only, the clock would only start ticking the moment we serve the bill, Malak. And we did so, man. There's the issue.
And so the bill was served, the only thing was, it was a wrong
Yes,
assessment.
yes,
So that does not cover.
yes. Malak, para 11, Malak. There is also an observation. This court also held that section 56(2) does not preclude the licensee from raising an additional or supplementary demand after the expiry of the period of limitation in the case of a mistake or bona fide error. This will not come in the picture, but they acknowledge the fact that the additional demand can be raised if there is a bona fide error. Relying on the very same judgment, my lords, the Honorable Coordinate Bench of the Council Court now. In APTCL versus so and so, WPC 2056 of 2016, my lord. Para 16, my lords. The judgment in Prem Cotex is discussed, my lords, and para 18 thereafter, my lords. The obligation of the consumer being from the date when the bill is issued, liability to pay the same only arises from the date within which the bill is required to be paid. That is the observation.
The obligation of the consumer being from the date when the bill is issued, liability to pay the same also arises from the date within which the bill is required to be
paid.
What is MFS10?
The issue with regard to in this matter was, my lords, the MF is a multiplying factor to be put in moment a certain category of consumer, which is a commercial consumer, goes from a consumer A to B. The multiplying factor would increase accordingly. A consumer who had then applied for extension of load, the multiplying factor for that consumer should have been 10, but the APDCL had wrongly applied the multiplying factor of 1. So the moment that was discovered and a supplementary demand was placed, my lord, that was challenged before the.
Anyway, this matter pertains to mistake. The bill is already there.
Yes, yes.
It is just the mistake in the amount.
Since he's raising a objection with regard to 56(2), my lord, for that very reason, my lord.
My lord, in this judgment, my lord, I'd like to, my lord, point out one thing, my lord. In this, my lord, the bill raised, the first bill, my lord, which was wrong, my lord, as per their, my lord, claim, my lord. It was raised pursuant to an order passed by the appellate authority.
Correct.
So, my lord, the day, my lord, appellate authority passed the order, asking them that between 2 dates, my lord, that from 27/8/2014, it should be counted, my lord. So, my lord, from that day, my lord, it has become due, my lord. In this case, my lord, in this particular case, my lord, there is no such order of the appellate authority. This particular, I would like to differentiate, my lord, on the ground that, my lord, this bill was raised as per the direction of the appellate authority, my lord. Though
The other bill the second bill also was raised.
my lord,
In the first bill, there was a wrong calculation.
No, my lord, that was not raised by as per the order of the appellate authority, my lord. Appellate authority has categorically said, my lord, the last line, my lord, I would like to emphasize, my lord, a bill cannot be raised after, my lord, appellate authority passed an order. 3 years after, my lord, passing the order.
Not 3 years. Where's the question of 3 years? The order
My
was
lord,
passed in 2000.
my lord.
Order appellate forum was 2015.
15, my lord.
And this is after 2 years.
My lord, 2 years. That is 2 years, my lord. My lord, it cannot be, my lord, a never-ending issue, my lord.
A mistake does not give you any right.
End of the day, my lord, public revenues, public revenue.
Mistake does not give you any right.
Well,
as the Supreme Court has held. Mistake does not confer any right on any person.
Well, then, my lord, my lord, I have not gone through this.
No, sorry. No adjournment. Don't even try. I'm not allowing it. You have not gone through, sorry. 2017, you had 7 years to go through all the judgments. Yes, just tell me one thing. This the two bills. What are the difference?
Well, 2 lakhs, I'll
Page 25. And there's 14 lakhs 73,957. And,
2,87,982.
huh?
2 lakhs, my lord.
No, no, no. No, the bill at page 25 is 14 lakhs.
Yes, 14,73,957.
Yes,
The page thereafter, my lord, will make it clear.
that is, ah, ah.
At the bottom, my lord.
Yeah.
The bill amount was so and so, 18 lakh initially.
Ah,
The amount paid was so and so. Amount to be adjusted was so and so.
bill amount was. Okay. No, it cannot be.
Because they had made a statutory deposit of 50% also, my lord.
Amount, bill amount is 18 lakhs.
Yes.
Amount paid is 33 lakhs. How can it
Yes,
be?
because the initial assessment was much higher. That was the assessment.
Any amount adjusted was 14.
Yes.
My lord, kindly come to Lordship, my lord.
Just a minute, just a minute.
27, my lord.
And amount, adjustable amount as per, so another additional 2 lakhs
2 lakhs.
is to be added.
Yes. 2,87,900.
My lord, page number 27, my lord.
Yes, 27, yes.
So the amount, my lord, is written, my lord.
Hmm.
Revised assessment bill period 12/11/2013 to 27/8/2013, my lord.
Yes.
My lord, second para, my lord, on the basis of AG audit inspection report verdict of appellate authority, my lord. So, my lord, that is what I was pointing out, my lord. This order was passed, my lord, as per the direction of the appellate authority, my lord. And my lord, section 56 says, my lord, if, my lord, it is continuously not shown, my lord, it cannot be, my lord.
So this is with regard to theft of electricity or unauthorized use?
Theft of electricity, the criminal charges apparently have been dropped.
And that's
the
a different
assessment will
issue.
continue.
That's a different
Yes.
issue. So what is the petitioner's case? That because the charges have been dropped, so they should be acquitted,
Yes. They're saying that they're absolved of their liability.
absolved of the liability to pay. And your case is that
Simply put, my lord, the appellate authority only said the period has to be from so and so, so and so. That we have not altered in any way. Following the appellate authority's order, we had issued a assessment bill, my lord. Subsequent thereto, my lord, the audit conducted an inquiry and found that the assessment was erroneous because we had applied a wrong formula. Thereafter, we
no. What about their submission that the
yes,
that the
those are separate.
acquittal in
Yes,
the
but
criminal
that will
case?
have no bearing, my lords.
Where is that judgment?
Yes.
Yes. Where?
para 16, my lords. Para 16 thereafter, my lord. It's a long paragraph. May I read, my lord?
Yes.
From subsection 5 of section 154, it can be
No, where's the main portion? Where does it say that they will have no bearing?
and I'll just come straight to that, my lord. Para 19, my lords.
Yes.
Para 19, the Honorable Court, my lord, refers to para 17 of the judgment of the Supreme Court, my lords. It is within
Yes, yes.
Placitum D, my lords.
Yes.
All instances of unauthorized use of energy may not amount to theft of electricity within the meaning of section 135 of the Act. But at the same time, the theft of electricity which is covered by 135 1A of the Act without prejudice to the other provision, the licensee or supplier, as the case may be, upon detection of theft of electricity, is empowered so and so. Thus, it is clear. Thus, it is clear that the authorities under the Act are empowered to make a provisional and final assessment by invoking powers under Section 126(1) of the Act, even in cases where electricity is unauthorizedly used by way of theft. When a consumer deposits the assessed amount, the licensee or the supplier has to restore the power supply. The assessed amount referred to in this aforesaid proviso relates to assessment which is contemplated under Section 126(1) of the Act. There is apparent distinction between Section 126 and Section 135 of the Act. Section 126 forms part of the scheme which
No,
authorizes.
no, where is it regarding the acquitted in a criminal case will have no bearing on that. Where
Because,
is
my
that?
lords,
Where is it?
these
Okay.
are on separate, my lords, criminal trial, my lords.
I know, but you said that it is here. That's what there's no point reading
No, they are
something.
separate proceedings altogether, my lord. But this is what I wanted to point out.
Let's
May
say
I
that.
convey?
No, don't try to take us on a ride.
No, my lord, that
You
was
see,
not my endeavor.
you see, if it is not there in this judgment, say that it is not there.
No, but
Why you want to
fact-
read?
Yes. The assessment under 126 or the liability that may follow from a proceeding under 135 is separate, my lord. One has.
Maybe, I'm not on that.
Yes,
135, 126 may be different.
yes.
I'm not on that. That is only with regard to theft and maybe unauthorized use of electricity. The issue is whether the acquittal by a criminal court would ipso facto have any bearing on the proceedings under 126 and 127.
From my limited understanding of this paragraph, my lord, it probably will not, my lord.
Where does it say in black and white? It's not there.
It is not there. It says they are separate proceedings.
Correct.
altogether, but
135
yes,
and 126 is different. That much we know.
Yes, my lord.
126 does not talk about criminal liability or criminal cases or criminal courts. Neither does 135 talk about criminal courts. This talks about how the licensee will make the assessment. That's a different issue.
Yes, my lord.
That's a different issue altogether. There's 135 and 126 does not talk about the difference between the criminal courts and the action taken to be taken by the licensee.
Yes.
Those are different. Are you taking me to this? So what has the criminal court said?
Well, it's there, my lord. Last,
Now, criminal court will be with regard to what?
my lord, last considering the fact that the accused has already made the outstanding payment to the concerned authority, instant proceedings stand discontinued against him as per relevant provision of electricity.
Anyway,
Accordingly, the instant case disposed.
criminal cases. So how can where's the question of sending him to jail when he's paid the dues here? Can you send?
That will not arise, my lord. But the liability, the civil liability will remain, my lord.
Civil liability will
Yes,
remain.
Yes.
But why did you file a criminal case? And that's not my, unless, of course, he's been unable to pay, that's a different issue. Anyway. So where is the initial assessment, final assessment? As per 126, there must have been a final assessment made.
Yes.
Where is that?
It is not part of the project.
Huh?
No, that's not part of the report. Upon can plan.
Okay, right. Heard Mr. G. Goswami, learned counsel for the petition, and Mr.
B. Chaudhary.
B. Chowdhury for the APDC. This writ petition has been filed by the petitioner challenging the order dated is it 25/7 or 26/7?
Right.
Twenty-five seven.
25/7.
25/7/2017, by which the revised assessment bill of the electricity charges for the period 12/11/2013 to 27/8/2014 has been revised. No. By the way, has been made. Full stop, huh? Full stop. The petitioner's case is that as the issue of as the payment for theft of electricity had been decided by the appellate forum in terms of section 127 of the Indian Electricity Act 2000. While order dated 25/3/2015 passed in appeal number 09/2015 and an assessment bill had been made in pursuance to the said order dated 25/3/2015, the said bill could not have been revised by the impugned bill dated 25/7/2017. Just read this. Assessment bill dated 28/3/2015 had been made. Order dated, comma. The said bill dated 28/3/2015 could not have been revised. Correct. You see, prior to the under 126, there'll be a provisional bill and there'll be a final assessment bill.
Yes.
Then only that's
Yes.
put to challenge.
Yes.
Correct.
Yes.
So we don't know the
Final assessment bill
initially.
my lord. That is perhaps is mentioned at page 26. The there is a, in bold, my lords, assessment bill amount. Because it
Okay,
was,
we'll leave it blank,
Yes.
otherwise this is its next paragraph. The petitioner's case is that the APDCL had initially made a provisional assessment and final assessment bill under section 126 of the Electricity Act, Indian Electricity Act, of the Electricity Act, 2003, hereinafter referred to as the Act, for alleged unauthorized use of electricity. Unauthorized use or theft of electricity, which one?
unauthorized use and tampering, my lords.
It's very different.
Yes, yes.
Unauthorized
use.
So it should not be theft of electricity.
Yes.
Change it to,
Theft.
earlier we said theft, no, make it unauthorized use of it. The appeal filed by the petitioner under section 127 of the Act was decided by the appellate forum while order dated 25/3/2014 in appeal number 09/2015 as follows. Page 24, you think. Next paragraph. Pursuant to the direction passed by the appellate forum in appeal number 09/2015, the APDCL issued a fresh bill which was lesser than the final assessment bill made earlier. Full stop. As per the new bill dated 28/3/2015, the petitioner was to pay an additional amount of rupees 14,73,957. The same was paid by the petitioner. Full stop. Next paragraph. The grievance of the petitioner is that after payment of the bill amount of rupees 14,73,957, the APDCL had revised the amount payable by the petitioner by adding a further 2,87,982 while revised assessment bill dated 25/7/2017. Full stop. The petitioner's counsel submits that in terms of section 56(2) of the Electricity Act of the Act, the amount of rupees 2, so and so, 2, so and so, which was not reflected in the assessment bill dated 28/3/2015, could not be recovered from the petitioner. As the same was not recoverable after a period of 2 years from the date when such sum first became due. unless the said amount had been shown to be continuously recoverable as area of electrical charges, as area of charges for electricity supplied. That's all. That's it. That's your case, entire case, I think. Anything else? 56-2, that's all.
Yes, my lord. And next, my lord, the judgment which has been quoted by my friend, my lord. The judgment which has been quoted, my lord. Dear my lord, this appellate authority, my lord. Here, my lord, this first bill was raised as per the direction of the appellate authority, my lord. And so, my lord, my humble submission is that, my lord, they cannot raise a second bill, my lord.
Full stop. He further submits that as the assessment bill dated 28/3/2015 had been made in terms of the direction passed by the appellate forum in the order dated. Where is that order? In the order dated. So pass order dated 25/3/2015. Passed in appeal number 09/2015. The revised bill dated 25/7/2017 could not have been issued as the same was not in terms of the order dated 25/3/2015 passed in appeal number 09/2015. I think that's the case. So, sir, Mr. Anything else? That's all. Mr. G. B. Chaudhary, the learned counsel for the APDC, on the other hand, submits that the initial assessment order dated 28/3/2015 was revised by the reassessment bill dated 25/7/2017 in view of the fact that the office of the
Auditor General, my lord.
where is that page?
Yes. The affidavit in opposition, my lord.
In view of the fact that the
Page 14, my lord, it starts.
page,
It starts at page 14 of the affidavit.
is the fact that
And relevant is, my lord,
the office of the accountant general had observed that the method adopted for calculating the assessment bill dated 28/3/2015 by applying clause 4.2.2.4 of the
AERC Electricity Supply Code.
AERC Electricity Supply Code was incorrect.
Yes.
As the same as the said calculation could only be applied when
In case of
the same was in respect of an incorrect or stopped meter.
yes.
Full stop. Not full stop, comma, where no malified intention of the consumer would have been
Certain or attributed.
could have been attributed. Full stop. On the other hand, in the case of tampering of meters, comma, which tantamounted to theft, comma, the willful act on the part of the consumer required that the calculation of the electricity bill should have been made by applying the provisions of clause 5.8.4.4 of the AERC supply
Electricity
code,
supply.
electricity supply code, comma, which provides for assessment of consumption in case of theft of electricity. Now, how do you, is there any difference between theft and unauthorized use?
The the intention, Madam. Again, the judgment in civil law is not, it discusses what is unauthorized usage and whether each case of unauthorized use of electricity will amount to theft or not. That's
So what does it say?
it says, Madam, I mean, just read that. Yes, Madam. Para 21, Madam, of that judge, Chippewa judgment.
That's 21.
Yes.
Yes.
This again referred to the judgment of the Honorable Supreme Court in Southco. Para 19 is quoted, my lords, in under para 21.
Yes.
Yes, ma'am. From the scheme of the act, it appears that after so and so inspection, the term unauthorized use of energy is of wide connotation. There may be cases of an unauthorized use of energy not.
No, where are you reading?
Para 21.
Yes. Para 19 speaks, we also do not
Yes,
find.
Yes, madam. Classitum B, madam, of para 19.
Yes.
There may be cases of unauthorized use of energy not amounting to theft, which are cases with exceeding the sanctioned load or using electricity in the premises where it is used, where its use is not authorized, etc. But at the same time, when there is an allegation of unauthorized use of energy or tampering the meter, such cases of unauthorized use of energy include theft as defined under section 135.
Yes, what have I said? As the issue involved pertain to the unauthorized use of electricity by tampering with the meter, comma. The case also came within the definition of theft as defined under section 135 of the Act. Full stop. In this case, now in support of a submission, as relied upon the judgment of this court in Shiv Alloy Steel versus Assam Power Distribution Company Limited and others, 2021 4 GLR 558. he accordingly submits that when a mistake has been committed by the assessing authority, by the licensee, in making the bill, electricity bill, the mistake committed can be corrected by the APDC. Next, I have heard the learned causes for the person. Clause 4.2.2.4 and 5.A.4.4 of the AERC Electricity Supply Code is reproduced here in below as follows. The next para, right?
It's not been filed.
Huh?
It's not there on record. I'll give it now.
Please give it.
Yes.
And then clause 56,
Section 56.
section 56 bracket 2.
Yes.
Of the
Electricity Act 2000.
act is reproduced here in below as follows. What else do I need?
But the judgment that I relied upon, my lord, of the Supreme Court in plain text 56. That when does the amount first become due?
Para 10, no? Is it?
That's para 10, 11 colors.
That's all. Nothing. Hearing concluded, judgment reserved. It takes too much time, by the way. That criminal matter, I don't think I have to mention. That has got nothing to do with it. Not only. Plus. Yes, madam.
Should we have received an affidavit on 19/9/24? We'd like some more time to file a reply to it.
What is this? You are challenging what in this case?
Such a similar matter to the previous one, the assessment bill was challenged.
Assessment bill was challenged by way of 127.
Yes, sir.
Was there a 127? So there's an appeal. Okay, so it's similar matter. So you have to file reply.
Yes.
Okay, Miss
P. Agarwal,
P. Agarwal appearing for the
petitioner, Mr. SP.
for the petitioner. Submit that affidavit in opposition. No, submits that the petitioner would like to file a reply to the affidavit in opposition. Press allowed. How much time?
3 weeks.
3 weeks is granted. List the matter after 3 weeks.
Lordship, in this case, we are directed to seek instruction that whether the petitioner had expired or not. We have tried to contact them. The number which was provided to us, that is not valid anymore. So we have sent them a letter, but till that no response has been made regarding that letter. So kindly sometime maybe give them Lordship.
Madam, if you see, the time was given to you in September.
Yes, Lordship.
Now, so and now 1 month has passed. So how will you contact if you have not been able to contact now?
We have sent a letter, Lordship, but regarding that letter, no response has been made. So we will send another letter. So at least.
No, letters will not do. Letters will not do.
No, just as a last chance, and date may be fixed in the month of November last month.
Miss
Abor.
A. Bora, Learned Counsel. Yes, any according to petitioner's dead or what?
Lordship, as per my instruction, Lordship, but I don't have the death certificate.
Miss A. Bora, learned counsel for the petitioner submits that. Despite sending a letter to the petitioner, there has been no response. He accordingly prays for one last chance to obtain instructions with regard to whether the petitioner has expired or not. On the prayer of the petitioner, lists the matter on your date.
No, it is too early, 29th of November, kindly.
Okay. No further adjournment shall be given on the said date. And on the same reason.
50
15 is also a similar matter, Lordship. This also relates to non-payment of contractor's bill.
Lordship, my instruction in this case is, Lordship, there is no work order or bill available in the department, Lordship.
Right, third, Miss A. Bora, learned counsel for, no communication, whether he's alive.
No, he's alive.
Okay. Third, Miss A. Bora, learned
There
counsel
was a
for,
work order which have annexed an annexure 1.
you
page
go
number
civil
10.
suit, madam, they are objecting.
It is written as it cannot be traced out, Lordship. Thus saying that the records cannot be traced.
Correct. Now, what is, this is not a court, or this is a court, where only the law has to be decided. Facts, now you go and prove it. Unless it is, since it's disputed, now what can be done? That is the risk you take. Let me say, Bora, learned counsel for the petitioner. And Mr. Upadhyay, learned counsel for the irrigation department. The petitioner's case is that the petitioner was allotted contractual work, namely invert commas, reconstruction of Bordi Karai irrigation scheme under one-time central assistance for 2004-2005 renovation of bypass channel at CH full stop 3950M invert commas close, valued at rupees 4,30,846 full stop. After completion of the contractual work, the petitioner submitted his bill amounting to rupees 4,30846. Full stop. However, the said amount has not been paid to the petitioner till date. Full stop. Next, sir. Mr. Upadhyay has submitted, Upadhyay learned counsel for the irrigation department has submitted letter number SDI/court case/73/2022/1454 dated 28/10/2024, which is to the effect that there is no record trace. Now, which is issued by the executive engineer, Sutia Division bracket irrigation, which is to the effect that there is no record trace till date in the division regarding work order and bill, regarding the petitioner's work order and bill. The contents of the letter dated 28/10/2024 is made a part of the record, is reproduced herein below. As follows. From here to here. First of the said letter dated 28/10/2024 is made a part of the record and marked as an X. First up. In respect of, now, due to the letter dated 28/10/2024, this court is of the view that the said issue requires facts to be proved, and as such, liberty is given to the petitioner to approach the civil court for redressal of the grievance as per law. The writ petition is accordingly closed. 2005.
Item 16.
Yes.
Today morning, when I talked to the authority, they are saying that they have almost completed the instruction now. Within a day, it will be furnished.
Okay. Mr. P. Nayak appearing for the PWD.
GMC.
GMC submits that as per verbal instructions received by him, the written instructions is going to be provided to him during this week. During this week. He accordingly prays for 2 weeks time to file affidavit. Praise the Lord, this is the matter of 2 weeks.
17.
No one appears for the petition on call. The petitioners contract work was terminated on 15/6/2020. Correct?
Yes, madam.
Oh, no, 8/5/2020.
2020.
8/5/2020.
2020. The agreement period is also otherwise over now. It was over in the year 2020. It was for a period of 12 months from 9/12/2019 to 8/12/2020.
The I tell you right, no one appears for the petition on call. Mr.
N. Chaudhary.
N. Chaudhary appears for
Respondent numbers 4 to 6.
4 to 6, while Miss
M. Burman on behalf of Mrs. A. and Lordship.
Miss M. Barman on behalf, while being A. Gayan appears for,
One.
that's point number 1. Full stop. Next para. So, as I've said that, no, then next. The petitioner's case is that it was awarded a work order for providing job service contract of multitasking staff for upkeep / conservancy work for CNS department at LGBI airport by the respondent number 6, on behalf of the respondent number 5. Full stop. Thereafter, an agreement was executed between the airport authority and the petitioner for implementation of the contract work, which was to commence from 9/12/2019 and continue until 8/12/2020. As can be seen from the above contract agreement. Yes.
In this case, I paid for 1 week time, my lord.
For what?
After a long time it has.
No, Mr. Counsel,
My lord,
your contract period expired
expired, my lord,
on 8 December 2020. What remains?
my lord.
What remains?
My lord, with liberty to approach appropriate court for.
No,
Compensation.
2020, no,
My lord,
after 4 years. You go.
Regarding area is there, my lord. All
Okay,
those
whatever.
things.
No prayer has been made in the
No,
regarding.
I am seeking only, my lord, liberty to approach the appropriate court, my lord.
You have got the liberty, no one is blocking you, no one is telling you not to go, you can go. This 2020 December finished, 21, 22,
Yes,
23, 24 is ending. There's nothing left in the list petition. Mister? No, what is your name?
Yes, sir.
Mr. S. Sahu appears for the petition. So subject, don't say on S, say on considering the fact that the agreement executed between the parties had expired on 8/12/2020. This court is of the view that the present writ petition has become infructuous. Accordingly, the writ petition dismissed as infructuous.
So dismissal shall not be barred for him to, you know, claim.
dismissal shall not be a bar for the petitioner to make any claim that he is of the view he is entitled to. No, that it is of the view that it is entitled to. As per the laws applicable in the state.
If it's matter of non-payment, your lordship, I need some time, your lordship.
Mr. R.R. Gogoi granted. How much time?
3 weeks, your lordship.
3 weeks time to file affidavit with regard to the claim for non-payment of contractual dues. This is the matter of the 3 weeks.
Obliged, lordship.
Yeah, please, your lordship. Since the petitioner has filed a counter affidavit, and I have taken the instruction on this, I have already written to the respondent authority.
He cannot file counter affidavit. He is not allowed.
Reply, sorry.
So what do you want?
I claim for the 1 week time
For what?
for taking instructions on that affidavit.
Why?
Lordship, there is a similar matter of cases already decided by this honorable court.
In whose
He is
favor?
referring this case in the affidavit.
Okay, right, on the prayer of the, yes, anything, Mr. Kalsi?
Date may be fixed, my lord, Your Honor.
Yes, madam, anything?
On respond number 1, on behalf of Mr. B. Assistant SGF,
So?
Central Government Council.
Okay. Mr. What is your name?
Mr. M. R.
Huh?
Amish Talukdar.
Mr. Amish Taluga appears for the petitioner.
Mr. M.
Mr.
R. Islam for Mr. M. R. Islam,
Mr. M.R. Islam appears for
2 and 3.
respondents number 2 and 3, while Miss
P. Purva, on
P. Barua appears on behalf of
respondent number 1.
respondent number 1. The counsel for the respondent number 2 and 3 waits for time.
It may kindly be.
List them on the prayer of the parties, list the matter on.
It will be too late, my lord, in the 12 to 14, in between.
No. Make it on 18 November.
I love this.
21. Yes, what to do? Yes, who's for the exercise?
We are waiting, your lordship.
Mr. R.R. Goel, counsel for the excise department.
3 weeks.
Please for
3 weeks.
3 weeks time to file affidavit number. This is the matter of the 3 weeks.
If your lordship takes up at 2 p.m., I'll show my lord that the order is without jurisdiction. Because to impose the penalty, a determination is required by the magistrate. Here the my lord officer has imposed the penalty absolutely without jurisdiction. Your lordship can my lord, close it my lord within 5 minutes. There are provisions of law.
Though there are provisions like number 3 weeks, if no instruction, that can be given, your lordship.
Right, no further no, there's a last chance, you say as a last chance, okay? No further adjournment shall be given on the next day.
Published.
Wait a minute, one more. 23 and 24. Yes,
May please your lordship. Lordship, may take the item number 24 at first.
24, yes. Yes,
Lordship, I am owner of a license of fair price of dealer. The respondent authority has cancelled.
so no notice was issued to you.
Yes, Lordship. No inquiry report is furnished to me.
No inquiry report for me.
Yes.
Which inquiry report? Where's the inquiry report?
Inquiry report they have submitted in the
Affidavit of position.
affidavit in opposition.
Yes, fair. Page.
Page number 36.
Okay, yes, madam, what to do?
My lord, records, lordship directed to produce the record, mother. Records are here, ma'am.
Huh?
We have received the record.
So what does it show?
My lord, or the temporary report was whether it was served up upon them or not, my lord.
Okay, you read it.
Yeah,
We'll take it up at 2.
My lord, better.
Okay.
Yes,
You see, there's one thing, whether any notice was issued to the petitioner.
yes, ma'am.
Where, how do you say notice was issued to the petitioner?
He appeared in the inquiry, my lord.
Appearing in the inquiry does not mean that,
My lord.
you see, whether he was given the inquiry report,
That I'll check right now, my lord. But
just see that, I think that's the only thing, correct?
hearing, my lord, 29/5, my lord, hearing date,
He might have
notice was
appeared,
given,
but whether he was given,
my lord.
he was given to understand that he was appearing.
My lord.
He was being given an opportunity of hearing with regard to all the issues that were taken against him. Anyway, we'll see that at
My
2.
lord, my lord.
Let's-
Sir.
Okay,
So
right.
that from that stage, Malad, because DC Malad personally visited and Malad on the basis of the DC's report, Malad inquiry was conducted by executive magistrate and it should everything correct. But
And what was found? And what was found?
Malad found Malad, your lordship will find in our affidavit, Malad. The report of this.
So it was closed when? When was the impugned
Malad cancellation was.
cancellation of fair price shop, no?
Yes.
It was on order dated 26/7/23, so July.
Malad, July.
So
Cancellation was in July.
so we'll say that the impugned order will be subject to the outcome of what? Or we will set aside. We'll have to set aside.
Allowed to, Malad, after.
Correct,
So-
correct, okay, right. Heard, Mr.
Yes, Bobby.
S. Barman, learned counsel for the petitioner. The dates are the same in both.
No, Lord.
No, okay, right, in item number 5211, huh? Heard, Mr. S. Barman, learned counsel for the petitioner, who submits that where is the impugned order?
You know the page number.
Huh?
Page number 26.
Who submits that the impugned order dated 26/7/23 issued by the Superintendent, Food, Civil Supplies and Consumer Affairs, Silchar, by which the petitioners retail license bearing number 3290 has been cancelled, should be set aside on the ground that the ground that the principle of natural justice have not been followed. Next para. The petitioner's case is that the petitioner has been running a fair price shop
Yes, sir, yes.
and license in that regard was issued to him. Full stop. However, why however, on the basis of the, where is that?
Inquiry report.
However, on the basis of the inquiry report dated, where is that inquiry report?
Inquiry report 12/7/23.
Page.
Page 37 of our affidavit, Malad.
37.
Annexure B of our affidavit.
However, on the basis of the inquiry report dated 12/7/23 issued by the respondent number, another party, issued by the executive magistrate, Kachar Silchar, the respondents issued the impugned order dated 26/7/23, cancelling the petitioner's license. Full stop. The petitioner's counsel submits that as the inquiry report had not been furnished to the petitioner to enable him to make a representation against the same, the impugned order dated 26/7/2023 should be set aside. Full stop. Ms. Udas, learned counsel for all the respondents, has brought the official records, and on perusal of the same, it is clear that the inquiry report dated 12/7/2023. No. Inquiry report dated 24/4/2023.
That manner is.
24, it's not 24/4/2023. The earlier one, it's actually not, it's not the executive magistrate.
And
It is the deputy commissioner.
Malad, that is
Kachar.
report, Malad, field report, Malad.
Ah.
He visited Malad after receiving various complaints, Malad.
Okay, the inquiry is correct then.
Executive magistrate. Malad.
No, but,
Malad.
okay, the correct, then you say with the inquiry report
It is field
dated
visit report.
the 12/7/2023 issued by the executive magistrate Kachar Silchar was not furnished to the petitioner prior to the impugned order dated 26/7/2023 being issued. Full stop. In view of the fact that next part, I've heard the learned counsel for the party. As the official records have clarified the fact that the inquiry report dated 12/7/2023, on the basis of which the impugned order dated 26/7/2023 had been issued, cancelling the license of the petitioner. This court finds that the impugned order has been issued without giving the petitioner a chance to make a representation against the inquiry report. The same is in violation of the principles of natural justice. As the same is in violation of the principles of natural justice, the impugned order dated 26/7/2023 issued by the respondent is set aside.
Malad,
Full stop.
not even there.
The next part, as the issue pertains to the closure of the Aganwadi Center, is it? No, as the issue pertains to non-maintenance. As the allegation maintains is with regard to non-maintenance of the registers.
And non-maintained stock.
Huh?
Stock also Malad not maintained. Malad. That is not-
Non-maintenance of stock,
and
besides overwriting
yes.
and change of values, the respondents are given the liberty to continue to start to issue a fresh show cause notice to the petitioner along with a copy of the inquiry report.
Deeply obliged.
If so advised. The writ petition is accordingly allowed and disposed of.
Lodge.
Then, where is the other one? Suspension, I'm not setting aside as on this.
Lodge. Lodge. Deeply obliged.
Sure, the suspension should be set aside also, I think.
Because it's apparent, Malad, because they were given and they have admitted, Malad. That will, if we do, if we have done
That
any
they have
mistake,
admitted, yes.
will not repeat it, my lord. That is admission is
Okay,
there.
out here also same thing, I think, same thing.
Same, my lord,
Same thing.
similar,
Same,
But,
same, huh?
similar.
but,
Same problem.
Lordship, earlier, this honorable court passed an order. This honorable court did not give an opportunity to conduct the inquiry and to pass hearing, money order,
Huh?
appropriate order. Earlier, this honorable court passed an order, setting aside the impugned order and directed to renew the fresh license.
It depends upon the facts, my lord.
Lordship, similar, I have filed a reply in page number 65, operative portion, last paragraph.
Page 65.
Yes.
Not this one, this one, no, I don't know what.
Full stop, full stop, right. Just, before you say allowed disposal, we just say, the
This one. Okay, no,
so it will be the respondent number 5, the respondent number 5 is directed to take a decision within a period of 30 days from today. No, 30 days from the date of receipt of a copy of this order. With regard to either continuing the process afresh by issuing a show cause notice to the petitioner or for renewal of the fair price shop license of the petition. Has it been, has the period expired?
No, Lord.
When is the period going to expire? Then how did this court give this thing? When is the period of the license going to expire?
Expired,
Already, my lord,
no expired.
one.
Oh my God, don't cut that, I just said, you don't even know. Next, give me the next.
Let me verify.
Yeah. I don't know what you're trying to say.
It is the order dated 22/10.
Huh?
22/10, my lord. My lord, I'm saying, my lord.
Lordship, on,
There are 20? Page-
Order dated, my lord, 22/10.
Lordship, on 22/10/24, itself, Lordship does place before the finance law.
Okay. It was sent to the finance, so no reply from finance.
Lordship just on 22/10.
Okay, so you send it to the finance. Okay, right. Heard Mr. Upadhyay, learned counsel for the respondents who submits that the irrigation department secretariat
Lordship.
has sent the proposal for sanction of the contractual use of the petitioner to the finance department on
22/10. The proposal status, Lordship.
Huh?
Proposal status. 1, 2, 3, 4, 5.
on 22/10/2024. So somehow, but there is no instructions with regard to whether the same has been considered by the finance department. Accordingly, Mr. Upadhyay shall obtain instructions. List the matter. Is finance a party here?
My lord, respondent number 3, my lord.
Who is the respondent number? Yes, who is for the finance department?
The other occasion, yes, so we have.
Yes, sir, what is your name?
Yes, so
H. Barwa, appearing on behalf of
we have.
B. Ovaila, counsel for the finance department shall obtain instructions with regard to the proposal sent by the irrigation department secretary for sanction of the contractual dues payable to the petition. List the matter. After 3 weeks.
Obliged.
Who's for the PWD?
My lord, Mr. B. Gogoi is appearing in this matters, my lord.
Huh?
Mr. B. Gogoi,
Where is he?
my lord, he is arguing in court number 2, my lord. In some
What to
particular
do?
mission.
They have not filed affidavit. You have to file affidavit. Okay. Right. The matter pertains to non-payment of contractual dues. Full stop. The respondent number 3 has submitted an affidavit to the effect that all the money for the contract has been given to the PWD. Full stop. As such, the PWD will have to explain as to why the contractual dues of the petitioner has not been paid. The PWD shall submit their affidavit in this regard within a period of 2 weeks from today. 2 weeks. 2 weeks, leave the matter on. Give a date.
Obliged, my lord.
7.
Yes.
Also, they have not filed any affidavit, lordship, it is not dependable of security deposit amount.
Huh? Yes, I know. We'll call your official. They are not taking.
My lord, our affidavit has been duly signed by the concerned authorities, my lord, but there are some problems relating to annexers, my lord. Annexers. That's why, my lord, it's not.
You see, it's not a question of annexure. It's a question of why you're not refunding the money. What have you said in the affidavit? We don't want what is there in the annexure. What have you said in the affidavit?
Let Mr. B. Gogoi appear in this matter, my lord.
Where is the affidavit?
Yeah, my lord.
You bring the affidavit, let us see. Give the affidavit. When did you complete the work, Mr. Counsel?
Lordship, in the year 2010. What do you mean? One work 50% has been released, other 50% has retained, and that is not released. There are two work, and in other work, 100% are to be refunded.
What is this? The engineer has withdrawn this no defect liability certificate. Well, after so many years. Yala not answering. When will you file? Let them file. We'll have to see. Right. Mr.
H. Bogoi.
H. Barwal, counsel for the counsel appearing for Mr. B. Gogoi. Counsel for the petitioner, for the PWD, submits that. The affidavit is ready except for some clarifications required, with regard to clarifications being required to be made in respect of the annexures. He has accordingly placed for how much time?
1 week time, my lord.
Or a week's time to file the affidavit on behalf of the PWD. Press allowed. This is the matter after a week. Let him file.
One fixed
Date, give a date after 2 weeks. It will be too short of a date. Say 2 weeks, not 2 weeks, give 2 weeks. 20 November.
Hello.
May I please your lordship? This is the non-payment of contractual lien, my lord. The, on 14/8/2000.
Yes, madam, what is this?
Lordship, petitioner's name found in list some of two petitioners, Vakil Vasumotari, in the objection of 40853997.
No, madam, this is, I'll tell you what has happened.
So when they will pay that is.
You see, this
second round of litigation.
this second round, contempt was closed. Then that they are in the list for payment.
When they will pay, it is not clear to right now, Lordship.
Huh?
As per my colleague's instruction, after Diwali.
Instruction, my lord, that
That is
they
not
in
written,
the
Lordship.
item number one of the council.
You said after Diwali.
After Diwali, verbal instruction.
Okay, right. Miss R.B. Bora, Learned Standing Council, BTC submit. Then as per instructions, as per verbal instructions.
That it should not be recorded, Lordship, after Diwali, Lordship, matter may be fixed, Lordship.
Why? Why?
First, in this case, actually, petitioner has to file affidavit also, Lordship.
No need. There's no requirement of affidavit. This second round.
Lordship, they have petitioner enclosed one document with by saying that representation of his, but this is not his representation, another person's representation.
I have already filed.
So Honorable Court directed the petitioner to file fresh affidavit stating the enclosing the appropriate application, Lordship.
Where?
Last order, Lordship.
Not.
Huh?
Last order, Lordship. Kindly see the page number 31, Lordship. Mohammed Muslim Ali has given the application. Petitioner is Atul Vasumotari, Lordship.
Lordship, I have already filed an additional affidavit on 29/2024, but that was not received by the bench. I have that is not received by the bench, so that is not the issue. Actually, we have filed two similar petitions. Some due to inadvertence, the representation filed by both the petitioner is different, but the main issue is.
You see, anyway, you have got to pay the amount at the end of the matter.
That is
Then?
Lordship. But here, Lordship, petitioner has to file first the affidavit.
Affidavit
No,
I
no,
have
no.
already filed, my lord. That is not in the record, that is.
I think we'll call your secretary again. I think we'll issue notice.
Yeah,
of
notice
contempt.
is already.
Contempt.
Lordship, I shall.
This time we'll send him, we have to take harsh
After-
measures, I think.
After Diwali, Lordship, they will perhaps preparing for pay, Lordship. After Diwali, Lordship.
This is a-
See, item number 1 is fixed on 11, Lordship, let it be.
Because he has given instructions that it will be paid after this Diwali period. They will be paid.
Let
He
it
said,
be on 11, Lordship, I also try to bring my instruction of that day, Lordship.
you will not bring any instruction, madam. Who are you trying to bluff?
When they will have pay, some, others also, petitioner will directly not pay,
Huh?
because they will be into Lordship, serial number, 1 is 11, Lordship, 1 is 16.
That is was submitted in the contempt petition, my lord. That list
One
was
is
submitted
14.
7, 25, 27, 28, 42, and 49. There's a serial number and.
No, you see,
on the
madam,
basis of-
you see, I don't know.
After Diwali,
Let the petition-
After Diwali for what? For
Whether
to
they-
come to argue the same thing you're arguing today.
no, Lordship, they will pay, I think, after Diwali.
I don't think so.
4 days.
The way y'all are taking the contractors for a ride is no joke.
I will not accept.
Y'all making them work and you're not paying them. You're not denying that they have work. You're not paying them. How did you give them the contract in the first place? Did you give them contract work without there being any money sanctioned for the work? Is it your case that there was no money at all? But then you all said that let us make the contractor do the work. We will think of paying them after 20, 30 years. Is that your case? It's not one case, madam. Every day I'm having around 10, 20 cases in this court. Only pertaining to no dues being paid by the government. You are making them do work, contract work. They are taking money. Maybe some of them are taking loans also. And you're not paying them, despite you saying that they have completed the work. What is this? What are the officers doing? Having their salaries despite doing their work. While here, they are contractors living, feeding their families, and they don't have any fixed income. There is a limit to how much you can cheat these persons. At the end of the day, it amounts to that. And you're the government, by the way. You're not an ordinary litigant, ordinary person. You're the person within whom everyone has trust. And you're the one who's not paying them. How did you give them contracts? When you give a contract, do you ensure that the fund is available in case the work is done? Or is it your case that let them use their money? Let them use their money, we will give it as time comes, slowly, we'll give them. That is not the way that you do work. You're not a ordinary litigant. You have to work for the people. You are of the people.
Kindly, it's item number 1, Lordship. I still come up with instruction. Item number 1.
And this is not a case that the petitioner has come for the first time in this court. She had come earlier. This was disposed of in 2021 with a direction to the respondent authorities to verify the claim and pay the petitioner. You did not comply. Petitioner filed contempt case in 2022. Contempt was closed in 2024 March on the ground that the petitioner's name is included in the list. Still not paying. So it is not disputed by you that you are liable to pay to the petitioner some money for the work done by the petitioner. But you're not bothered. You just want a date. Your officers are not bothered at all. Why do your officers give them contract works when there's no money for the contract? BTC owes how many people, how many contractors according to you? A rough estimate? More than? Only 1,000. Give me the list. That BTC list that was given to us by 1,000. I'm sorry, you don't even know that. Huh?
PWD model.
This is only with regard to the chief discretionary fund. Only one. I'm not talking about all the 40 departments. It's only under this chief discretionary fund, 1,988 persons. And everyone you owe lakhs and lakhs. How did you manage to issue orders without there being any money for it? Please take this seriously. You are making a fool of these people. Then you're trying to make a fool of this court also. You're not paying. Yes, he has to come twice to this court. The earlier writ petition was WPC 3997 of 2020. And this writ petition is of 4063 of 2024.
Petitioner filed 6 numbers of writ petition for non-payment of contractual.
Madam, I know. But this court has also got certain limitations. You just see every day how many cases this court has. Only with regard to non-payment of contractual dues, admitted contractual dues. Right. Miss R.B. Bora, learned standing counsel BTC submits that the admitted contractual dues payable to the petitioner may be paid after the Diwali. Accordingly, he prays that the matter be listed on 11/11. List the matter on 11/11.
Item number 30 is the same.
Huh?
Item number 30 is the same.
13 also same. 30. And out here is Mr. B. Chowdhury.
Last week, copy I had sent it, but lots of fix it on the date.
You have the same order. Out here you put Mr. B. Chowdhury for the BTC, huh? Same.
Supplementary orders 45. Supplementary admission 43.
No one appears for the petition on call. It appears out here notice was not issued. Then
Cancelled. This license was cancelled.
without notice. So why should we not allow the writ petition?
The basis of some inquiry is
No notice, inquiry, then you should have issued notice along with the inquiry report.
that is correct.
Then you're doing it behind the back of the petition. We will dispose it off on the ground, we'll allow it. He's not there, we cannot wait. Right, no one appears for the petition on call. Mr. S.R. Barwa appears for. Mr. J. Hunting appears for fund number 1 and 2. While Mr. S.R. Barwa appears for
From respond number 3 to 7.
3
From 3 to 7.
3 to 7.
Okay.
May please your lordship. My lord.
Oh.
My lord, may I pray for some other date, my lord? Mr. A.R. Who is not well, my lord. He is in Bangalore, my lord, for medical emergency. His physical condition is not good, my lord. So, my lord, any other?
No, it's okay. You stand.
And affidavit is filed, my lord.
This is proceed that registration manual. I have given. Lordship that under 14(7) lordship. The register is empowered to cancel the license.
Correct. I'm not on that. He can. But whether the principles of natural justice was followed, that is what is the issue. Was he given any notice?
This notice was not given.
Huh?
Notice, we can. In our affidavit, we have not said about a notice, Lordship.
But that is his case.
Notice.
So we'll set aside the order. You give a notice if you want. Right. Heard, Mr. Yes, what is your name?
Yes, Rana,
Yes?
Rana.
Rana, let's call for the petition. We have got, no, Mr. J. Hunting, we have got one and two. Sir. The petitioner's case is that he was issued a deed writer's license by the district commissioner on 12/11/2012. However, while order dated 30/05/2024 issued by the district commissioner. Which district commissioner? Bongaigaon. The deed writer's license was cancelled under section 14(7) of the under what?
Of the Indian Registration Act.
Huh?
Of the Indian Registration Act 1908.
Under the Indian Registration Act 1908. The petitioner's grievance is that no prior notice was issued to the petitioner, and neither was the inquiry report on the basis of which his license had been cancelled been furnished to the petitioner, prior to the issuance of the order dated 30/05/2020. Next para. Mr. S.R. Barwa, the learned counsel for the respondents. It's your submission or Mr. Hunting, his submission, no? Mr. S.R. Barwa, learned counsel for the respondent number 4, submits that the petitioner's license had been cancelled on the basis of an inquiry report. Preliminary inquiry report dated
22/5/2020.
huh?
22/5/2020.
Where do you get that date? Where do you get the date? Page?
Their affidavit, my lord.
Yes, but where is the date? Where
Page number 31. my lord.
31, Lordship.
Okay, no, this is the forwarding, no. Just a preliminary inquiry report which was forwarded by the subdivisional officer bracket C, North Salmara to the district commissioner Bongaigaon. By letter dated 22/5/2024. What about notice? What about this inquiry report? Anything whether he was served or not?
Because page 20 of the writ petition, Lordship.
No, forget that. He was he went. He was given opportunity. But his case is that he was not given the inquiry report. So what have you got to say? Whether he was given or not?
It's not mentioned in our affidavit.
He submits that with regard to the averment made by the writ petitioner, that the petitioner had not been furnished with a copy of the inquiry report or the complaint on the basis of which his deed writer's license had been cancelled, has not been addressed by the respondent number 4 in his affidavit dated 26/9/2024. Huh? Full stop. I have heard the learned causes for the parties. Full stop. A perusal of the contents of the writ petitioners appears to show that the petitioner was, no, shows that the petitioner was given an opportunity of hearing by the district commissioner, Bogaigaon, before the impugned order was issued. However, the petitioner has taken a categorical stand that the preliminary inquiry report and the complaint on the basis of which the they just said the complaint and the preliminary inquiry report, on the basis of which the impugned order dated 30/05/2024 was issued, had not been furnished to the petition. Full stop. Next para. In para 11 of the writ petition, the petitioner has categorically stated that the inquiry report had been made by the respondent number 7 behind the back of the petitioner. You have not taken a stand that the inquiry report has not been furnished to you.
Not just.
In view of the above, Mr. S.R. Barwa shall produce the official record on the next date to clarify whether the inquiry report was furnished to the petitioner prior to the impugned order being issued. List the matter on when, which date?
After 2 weeks.
Date 13. You bring the official records, it'll make it clear. 13/11. 13/11.
Article 31.
You just.
May I please? As per my instruction, the order is common, that complied with. Only thing is that in our writ petition, there is a one more interest part, which is in, there is some interest part
Interest is a different thing. No, this is a contempt, Mr. Council.
yes.
Sorry. Right, Mr. H. H. Anand, counsel for the petitioner submits that as per instructions received by him, the petitioner has been paid his contractual dues. Accordingly, the order dated 7/6/2019 passed in WPC 100 of 2019 has been complied with. The contempt petition is accordingly closed. Acha, you right? Mr. R.R. Gogoi appears for
For the contempt for the respond number 2.
for respond number 2, huh?
Obliged.
22.
The contempt, no verification.
Newly completed.
What? Complied.
Well, not even the process of the first phase that any company called Nitco was given to verify. That first phase, this files has not gone, my lord. The second phase has been given to them to verify their, that is not complete, my lord.
So what is to be done?
My lord, Lordship will allow some time to get the verified, my lord, because on the first phase, payment that lease has been prepared. Second phase, that has not been verified.
Their official called my client, my lord, and they are saying that they have prepared the list and they have sent the contempt is different. This is here. And they are saying that they have sent to CM Mr. Pramod Boro for approval. Now they are saying that my name is not found out here.
No, but
What is
verification,
going on?
second
They
phase.
have
is
crossed the
verification.
line.
That verification, no, I have the instruction, my lord, verification has not been done, my lord. Because it is, this
Verification
file
is
has been
not
sent into the second phase. First phase verification, then the lease has been
And
prepared.
who is hiding my file?
First phase verification has been done
Yeah, then that lease, entire, all the leases come. Second
and
phase,
payment has been made.
some payment that lease has been.
First phase payment has been made or not?
First phase, my lord, as per I am case appearing these payments, I have no instruction on payments.
Why? We
Because
want
money has come in some
Huh?
case, money has come in every department, my lord.
money might have come to your pocket. He wants it now transferred to his pocket.
That I don't have.
You should not keep other people's money in your pocket. Give it to the rightful pocket.
That his file is in the second phase, my lord, so that is not complete, my lord.
But when will it be complete?
My lord, that instruction is not there, my lord, but he's coming, his file is among the left out what, and the second phase it has been sent for verification, my lord.
This is the contempt for 2022. Yet the list has not been prepared by the petition.
So when will the verification be completed?
Well, I'll get that particular instruction, my lord, because file had been sent.
And what did you do? What did you come here for today for?
My lord, that,
To ask for time to get the instructions?
no, my lord, my lord, that means my instruction is that, my lord, that verification has not been done. Only the verification has.
Verification of the second phase has not
Second
been
phase
done.
not been complete.
First phase has been done.
First phase has been done and everybody lease has been prepared according to
Huh?
the.
What has been
List
prepared?
has been prepared, my
Huh? List.
list.
List
But
of
only
what?
That particular list, my lord, that after verification, because initially the amount was around 22,000, it has come, 2,200.
His name is in the list.
No, his name is not left, because verification has not been done.
Not yet been done.
Verification in the first phase has been done.
First phase has been.
Achha, there are many phases.
No, because
How many phases are there?
what had happened, my lord, list has been sent, verified. And that list has all been prepared, my lord. And he is among the left out. So second phase, it has been again sent to the company to verify. He is in the second list.
So when will it be completed?
My lord, that will take time. I will get the
No, it
instruction.
cannot take time.
I'll get the
If you are not willing to comply, then we'll have.
No, we
Ah.
definitely have to comply because initially the amount was 2,200 crores, with them the verification was, it came down to 1,200 crores rupees, madam.
Maybe. That is what I was telling the earlier council. Why are you giving contract works without having money in hand?
At that particular point of
Ah.
time, something has.
Supposing your the BTC tells you, Mr. S. Bora, you please work. I will give you your fees after 30 years. Then
Then,
I think according to you it's fair, no? That's what you're doing to him.
well,
Mr. Bora, you'll get your fees after 30 years. You please carry on doing pro bono work for the time being. Not pro bono, your fees are there. We will do first phase, second phase of verification, and after 30 years we'll give you.
after 2 weeks, madam, I will get.
This
the
is not
exact-
fair.
That's my, that is not fair, madam, I understand, madam.
Then what are you doing? There's a order passed by this court saying that it should be done within a certain period of time. And you are saying, we will do it, we don't know when. What is this? What are we doing here? We are sitting here to decorate the courtroom or what?
Lordship, post within 2 weeks, my lord, I will get the instruction from what second phase is going on, where the stage of the second phase, my lord.
You see, I'm not worried whether it's the 20th stage or the second stage or the half a stage. The order has to be complied with.
No,
This
order has to be complied.
22, contempt is of 22.
My lord, that I
Huh?
had to be compliant, my lord.
And the order is of 2021.
2021.
Now 3 years have elapsed. Forget about payment. You have not even completed the verification.
Lordship, give me one shot, I will get the instruction. What is the stage of the second phase of exercise, my lord?
In fact, my lord, on 9 August 24, they have issued one order where they are saying that the unspent money 63 crore for the financial year 23 and 24 is there. And now new budget for the financial year 24-25, 400 crore. They have also received. One is there, my lord.
They're just playing around.
Yes, my lord.
Playing around, probably putting money in, I don't know, wherever, but not in your pocket, that's all.
Well, SOPD fund has come, it has been allotted for 10% of the amount for the sources of the liabilities, madam, to each and every department. As per the list, it will be disbursed, madam.
No, just tell me one thing. When you give contracts or supply orders to individuals and to companies, firms, do you do that without having any budget, or is there funds available already?
Earlier, madam, that was the process was taken earlier, madam.
Then if that was the case,
Now the new.
no, so correct. So if that was done earlier, have you identified those people who have done it? Has there any exercise been done by you? Huh? So as to pinpoint and take action against those persons for cheating. If that is your case, if those persons are cheating people, then why are you not taking criminal action against them?
Even person some fake or work order also, so that we have identified and that we are taking action against them.
You have taken action. Tell me please give me a list of those criminal cases that you have registered.
I don't have that instruction on that, but we have detected those sanction
You
orders.
take action. You take action. I have not heard of one till now. I've been sitting in this bench for quite long. Every day I'm having these type of cases. I've not heard of one case you have taken against any government official on the ground you have just stated just now. Fake orders have been issued. Maybe. Where's the action taken by you? Maybe this is all for consumption of the court only. Nothing has been done in the offices.
I'll get the inspection within 2 weeks. My lordship post it over 2 weeks, then lordship will pass. May I say order for that?
Mr. L. Bora submits that he will obtain instructions as to why verification of the petitioner's case has not been done, even after 3 years. This is the matter. Give it.
Okay, sir.
14. Knowledge.
Item 33.
No one appears for the parties. List the matter. After 2 weeks.
34.
Same situation.
Let the officer appear, then we'll not think so.
I don't know. Officer had appeared once in another case. And they have said that it would be paid within thing. But how many times can you call them?
They have taken in the affidavit is my lord atrocious. They say SOPD, they get some amount from the government.
10% should be.
So out of the 10%, they have prepared the limit, it's 2 months.
take some special, because these people are taking loan every day. We are finding every Wednesday, there is a cabinet meeting and a decision to take loan. Take loan also here and pay us.
Lordship, here, I do not have the up-to-date instruction. Lordship may allow me a short time. Lordship.
Even this court is tired. Court. Every day in and day out. I mean,
Incorrigible.
what to do? I don't know.
Short date, Miller.
I don't know how they've managed to issue all these work orders without having the money to pay for it.
No,
And
they have-
with
in this case, they have paid partly.
No, in all the cases they paid partly. Most of them.
Oh,
In most of the cases they paid partly, but they have not paid full. Always not full, and of course in some they have not paid at all. So you can't say there's a contempt.
no. Here after order, nothing has been paid.
Okay. Let's
Earlier,
get,
50% was paid.
you see the one before this, verification also not done.
I think, my lord, my learned friends should come up with some constructive instruction that within such and such time, maybe in one installment, 2 installment, will make the payment. We can appreciate, my lord, financial constraint, but it can't be that they will not pay nothing.
I told you this BTC again.
BTC.
You see, this is the chief's discretionary fund. Out there, there's 1988 persons to whom they've got to pay. And then the other 40 departments have got separate lists of their own. Now you can imagine the amount. And then the case just before this was that he was not included in this list. So he's going to be considered in the second verification process.
In our case, verification is done. But our
Lucky.
name finds place.
Yeah, lucky. Very difficult, very difficult. But I think you have got to seriously consider this issue. I mean,
Yes, Papa.
I mean, it's not expected of a government to ask someone to do work, admit that they've done the work, give them completion certificate, and not pay them. You don't expect the government. Maybe you can expect a person who has taken a loan, individual, because he goes bust, his business doesn't work, he cannot repay. That is all right. But for a government to do this to a citizen is a different ball game altogether. I mean, the only person you can really supposed to trust is the government. If you can't trust the government, then what will happen to you and me? Your fee though you will get somehow. Maybe, I don't know. Might not also. Anyway, right. Mr. V. Chowdhury, Learned Counsel for the respondent number 2 and 3, shall obtain instructions as to why the contractual dues of the petition has not been paid, though funds for the construction, the contract work must have been earmarked prior to allotment of the work.
There was an administrative approval also, my lord.
Approval. No, but administrative approval is easily given. It is the expenditure sanction order which is difficult to get. Administrative approval they give without money. It happens everywhere.
Hello, we'll give a date.
Give after 3 weeks.
Deep.
35.
May I please your lordship? Lordship, I'm for item number 35 on behalf of Mr. P. Mandar. Lordship, kindly pass over the matter for.
No, you say. Whether the ceiling proposal has been given or not.
Your Lordship.
Lordship, I have verified the total amount. Some portion is left out, Lordship, so a little amount, Lordship. There, I have called the officer, talked to the officer, he said, I will take care of it. A little amount, Lordship, all the rest, the huge amount has been already.
So ceiling proposal has been given to the finance and they have approved.
Lordship, that part, that amount was already, Lordship may see the order, Lordship. Early order, Lordship. Take on the Lordship. That was already recorded in the earlier order, Lordship. That part had been recorded. You have to give it in part, Lordship. That has been already recorded in the, on the earlier day, Lordship.
No, you see, Mr. Council, there is a difference between approval of the amount, the budget claim.
Lordship.
After they give approval,
Lordship.
you have got to submit a ceiling proposal.
That is the, just now I have,
This one,
this.
this other one.
Group of papers.
This is the ceiling proposal. For how much?
Lordship, total amount I have calculated is 311.83739.
311.
0.83739 lakhs.
311.
Double one.
311.
0.83739.
So 311 lakhs.
Lordship.
Ceiling proposal has been sent.
Lordship.
But
the amount is less, Lordship, around 40 lakhs is less, Lordship. I have calculated it
yes,
now.
41 lakhs.
Lordship,
Less.
approximately, Lordship, 41 lakh.
Then
There, I have talked to him, Lordship. He said, I am going to do it today.
he'll do it today. Who said?
The law officer, Lordship.
Law officer, which department?
Veterinary, Lordship. Veterinary. and-
He's going to do what?
He will send a proposal, Lordship. It goes-
Ceiling proposal
Lordship.
for the remaining balance amount
Lordship.
to the finance department.
Lordship.
Who is for the finance? Yes, madam, what about the ceiling proposal that has been sent to you? What has been done?
Lordship, we haven't got any update exactly related to the ceiling proposal, because as per the last order, it was supposed to be getting the.
When did you submit the ceiling proposal?
Lordship, that I am not clear. Lordship, I am providing it to her, Lordship.
Yeah, please provide
Get the
it.
instructions along.
Okay, yeah. Anything else you want to say, madam?
No, Your Lordship.
What is your name?
M. Borgohain.
Miss M.
Borgohain. Borgohain.
Borgai. Appears for the petitioner.
I am Bhagavati for 1 and 2.
Mr. M. Bhagawati appearing for the respondents number 1 and 2 submits that in terms of the order dated 28/8/2024, the ceiling proposal for rupees 311 full stop 83,739 has been sent to the has been sent as a ceiling proposal to the finance department for payment to the petitioner. Full stop. He submits that though the ceiling proposal is less than the amount payable to the petitioner, which is rupees 352.61, the law officer of the Animal Husbandry and Veterinary Department has informed him that a ceiling proposal for the balance amount will be sent to the finance department within
2 days.
within 2 days. Full stop. Next para, Mr. M. Bhagawati has also furnished a copy of the ceiling proposal for rupees 311.83739 to Miss M.
RM Barwa, Your Lordship.
R. M. Barwa, Learned Counsel for the Finance Department. Full stop. Next para, Miss R. M. Barwa shall obtain instructions with regard to the ceiling proposal, for which a copy of the same has been furnished to her. Full stop. Yes,
I'm appearing for respondent three.
who is that?
Intermediary between the respondent number one and two.
So you have got no role to play right now.
I'm just the intermediary.
Mr.
A Deka.
A Deka appears for point number 3. List the matter. After 3 weeks, 4 weeks, you were did. Come on which date? The Mr. M. Bhagawati and Ms. R. M. Barwa shall inform this court as to the fate of the sealing proposal sent to the finance department.
Matter. 57. 46.
Here I have received my instruction, my lord, to allow me time to file my affidavit.
Mr. S. Bora, General Counsel submits that instructions have been received.
3 weeks time only.
He submits that affidavit will be filed within 2 weeks. List the matter after 2 weeks.
Can a date be fixed once?
Your date.
21st.
Let's go.
37.
But in this case, I am not please. Respondent one lordship. Sometime may be allowed for filing.
Mr.
And Goswami.
N. Goswami, Learned Counsel for
Respondent one.
respondent number 1.
I'm for.
Are you filing anything?
I filed to I'll get the instruction. And give us.
And Mr. N. D. Nath, Learned Counsel for respondent number 2. Are granted 3 weeks time to file affidavit. List the matter.
Date.
No hurry, 2024 matter.
Malaj, contract pertains to 2014.
Then when did you file a writ petition?
Rate was filed in 2022.
No hurry.
Malaj, I'm a small time contractor.
45 and 46.
I'm grateful.
May I please, Lordship? Lordship,
This item?
45.
45.
Now, one thing. You see, the review that has been filed.
They have filed here.
Oh, you okay, you have filed. You have Miss D. Angada.
I'm petitioner.
The content though I can take up,
Yes.
but the review I cannot take up because it is by Justice Shyam. The review that they have asked for is the order passed by Justice Shyam.
Yes, yes.
So where is that? Where is the review petitions counsel? Mr. R. M. Das. R. M. Das is the counsel. So we segregate this contempt petition from that, right? Ms. D. Angana, learned counsel appears for the petitioner and submits that the review petition number 191 of 2024 cannot be heard by this court as the said judgments for which a review has been paid for pertains to have to be decided by the court of Mr. Justice, Honorable Justice Sumanchi. Considering the above, considering that the contempt petition pertains to a judgment in a different case, the contempt petition should be segregated from the review petition. List the contempt case after 2 weeks. Good day. Then for what?
For what?
Water. So this contempt, this review petition has been filed by you.
Yes, sir.
This review petition will have to be heard by Justice Suman Shyam, not by me. So we'll list it before the appropriate court, right? Huh? Item 46, you right? Mr. Arendas.
See, Sharma.
Where is your affidavit? Bakalinama. Not there. Who is this Arendas?
But we just standing council of water.
Okay. Mr. C. Sharma, learned counsel for the review petitioners submits that the review petition should have to be laid before the court of the Honorable Mr. Justice Suman Sheikh. Registry to verify the same and list the matter before the appropriate bench.
Forty-seven.
Please, Lordship. Lordship, in this case, earlier the notice was issued upon the respondents and we have taken steps, but in the office note, Lordship, there is no indication whether service is completed or not.
No, you see, the thing, the notice was issued only on 14. And today is 28. So 2 weeks back only. So we have got to wait.
Lordship, in that case, we may be allowed to take dusty service because Lordship contract agreement is only till 31st.
Correct. Miss
David.
R. Devi appears for the petitioner, while Mr. S.R. Barwa appears for
Respond number 1 to 4.
1 to 4. Full stop. Notice was issued to the respondent number 5 on 14/10/2024.
On
Full stop.
410.
14/10, as per office notes. As such, await service report. The petitioner has, however, given the liberty to issue notice, to serve notice upon the respondent number 5 by way of dusty service within 10 days.
10 days.
Within 10 days. Yes.
We have received one communication. In fact, our authority has also received a repetition copy on 24/10. So we need some further time for
You bring the records on the next day, that'll be clear.
record.
Yes.
Lodge.
Huh? You bring the report. Or what? You can file affidavit, you're not going to file affidavit.
Lodge will file.
Huh?
We'll file, Lodge, definitely will file.
Okay, right. Mr. S.R. Barwa, learned counsel for the state respondent is granted 2 weeks time to file affidavit in opposition. List the matter on, give it.
Record may also produce Lordship.
This is the matter of so on which date the records should be produced by Mr. S.R. Barwa.
Plus.
38 for hearing.
Right, Peter. The last appeal, the respondents will directly to take measurement in my presence. Thanks.
Yes.
And Your Honor, I am appealing for respondent number 2 and 5.
Yes.
Okay.
Yes.
I have gone through it. NAFS has agreed, I am also agreed with the measurement that is certified before the matter of EPN. We agree with that measurement which they have submitted for the EPN.
Huh?
The measurement which was carried out, they saying that it is not.
So they have agreed to 90 lakhs.
Yes, I am.
To pay. Then
also.
then what is to be done?
One of the direction maybe you should be deposit at that.
Huh?
To the corresponding.
No, now the question is,
One of the. It has written,
now that one part now that is settled, that 90 lakhs is settled. Now the only issue is with regard to that loan amount payable by respondents 2 and 5.
No, payable by respondent number 4 to Malatia. Respondent number 4, my. NAFS.
No, that
Respondent number 4. He is liable to pay my loan amount.
yes. Okay. Respondent number 4 has taken the loan.
Right.
Correct.
Right.
And your payment has to be made from respondent number 4.
From
Through-
EPL through 4. From EPL through 4, my. Here, my lord, it is mentioned and written that therefore the petitioner's bill must be certified, verified, and mutually agreed by both the parties, that is necessary NAFS and petitioner, and shows acceptance on the measurement. I have showed my acceptance. NAFS have verified and accepted the measurement.
Now DRT order is there also.
DRT order, it is in relation to the respondent number 4.
Huh? Yes.
It is in relation to respondent number 4. The amount which I am paying back, it has accrued for the works done by me.
Correct.
For the EPL. So now, EPL's letter reflects that if respondent number 4 and I agree with the measurement.
So why not paying? So this is there.
Yes.
Actually, appearing for 2 and 5 P. Goswami is.
Huh?
Then advocate for P. Goswami is appearing before division bench IJOL. So that's
Out
why
of station.
out
He
of
informed.
session.
Huh.
That's why I'm not the right person to.
No, so why don't you pay? Since you are taking the decision to pay. We'll list it some other day. Mr.
C. Talukdar
C. Talukdar has submitted
on behalf of P. Goswami.
a letter dated 21/10/2024 issued by the Deputy General Manager, Engineering Projects India Limited, and letter dated 7/10/24 issued by the Managing Director, NEEFS India Private Limited, which is to the effect that rupees 90 lakhs is to be released to the petitioner from the by the regional in charge by the Engineering Projects bracket India Limited. Full stop. The petitioner's counsel submits that the payment has not been paid to the petitioner till date. Leaves the matter on after 2 weeks. Give a date. Hopefully by then you will get. I hope.
Right.
I know.
Right. I hopefully they will pay.
Or do we close this? Do we close this or what?
If direction is given, my lord, to pay,
No, let it remain like this. Let it be. Because let the council be there. The council is not.
senior is also absent.
Yes.
How like?
Yes, ma'am. On the thing this is on last occasion, honorable court directed the respondent to file their affidavit. ma'am.
What is your case?
Hello, dear, the petitioner, the respondent authority published one NIP and the petitioner participated in that NIP matter. And the name of the petitioners come as L2 bidder matter. But the L1 bidder did not fulfill the condition of the NIP matter.
No, but you see,
NIP
has the contract been awarded to anybody?
No, my lord.
Is it a 2-bit system or a 1-bit system?
1-bit system, my lord, and the petition respondent authority.
So has the bid of the respondent, private respondent, is there any private respondent here?
My lord, two private respondent is there. my
Okay,
lord.
who is that
One
L1? Who is L1?
L1 is the
Respondent number?
respondent number 6, my lord.
So has the work been allotted to L1?
No, my lord.
Then
My lord, the department is trying to allot the work order to respondent number 7, who is the L3 bidder. my lord.
look, Mr. Counsel, right now, what right of yours has been violated? Let them take a decision, then you come and challenge.
My lord, so I have.
How
paid
can
the-
we say that they are trying to is of no use? It's premature. Your case is premature. I can understand if it was a 2-bit system and in the technical bid, all were qualified, then it's okay. But here it's a issue of, it's a 1-bit system, unless a decision is taken.
My lord,
What right of yours has been violated?
as per NIP, my lord, NIP is at least 12, my lord. And point number 1, my lord,
Point
rate
number-
should not be quoted as per schedule of rate below maximum 5%. Rate quoted
Correct,
more than
correct.
5% below will not be accepted. But here, my lord,
Page
page 14, my lord,
14. Yes.
not 14, my lord, page 15.
15.
Here,
Yes.
the rate of L1 bidder is 10.14.
Correct. So 10.14, so you, 10 the L1 is respondent number 5.
L1 is
Respondent number 6.
6, my lord.
So you
So,
said that,
so as per that, I am the L1 bidder.
Huh.
Because
so Mr. Counsel, let them take the decision. No, why are you taking the decision for them?
they have not issued the contract to me.
They have not issued the contract to anybody. Have they issued the contract to anybody?
At present, no.
Then how can you force their hand? They have to take a decision. When was the tender open?
Six on 30/10/2023. Last date of submission of bid is fixed on.
Mr. Counsel, how can you do that? Let them take a decision. Right now, what right of yours has been violated? Your case is that it might happen.
My lord, I am clear as L2 bidder.
Mr. Counsel, whatever it is their duty, it is not your duty. It is their job. Your case is premature. You might be L2. It doesn't mean that you see the lowest bidder or the lowest valid bidder has to get. It depends on many other factors. Your past experience, your financial status, all that. And let them take a decision whether you have to get or not. If you find that somebody else has been given, Then you come to the court saying that you're L2 and you're not being given. Not like this, when nothing has happened. Yes, Mr. Srinath.
Well, so for the instructions received from it's not complete instruction now. Otherwise, because of his poor performance, he was found to be L2 and he was not considered.
It has already been allotted, work has been allotted.
My information is known.
Then?
There is,
He's saying that it is a 2-bit, 1-bit system. Is it a 1-bit system or a 2-bit system?
but kindly give me some time. I have to go.
And he's saying 1-bit, then I don't know, the court out here saying that the court is how about the opinion that having held the bid of the petitioner to be technically responsive, whether such a ground would be valid. So it appears to be a 2-bit system, but he's saying it's a 1-bit system.
No,
The court's order appears to show that it's a 2-bit system.
technical and financially, if they are, then it will be 2B.
If it's a 2-bit system, here's the case. If it's a 1-bit system, it's premature. So y'all are not even sure on facts. The order of this court 13/12/2023 says that the court is however of the opinion that having held the bid of the petitioner to be technically responsive, whether such ground would be a valid ground. So when the technical bid is found to be responsive, correct, counsel for the party shall. Counsel for party submit that they may be given time to go through the amendments in the writ petition. Praise the Lord, this is the matter after 2 weeks.